Okay, we're here on cause number DC 121-1234. Unusual cause number. Council, make your appearances.
Andrew Schumacher with Winstead PC, representing State Farm Lloyds.
And Patricia Nasworthy, representing the insured Joyce Taylor.
All right, let's there's a motion to appoint umpire. I kind of wanted to talk to y'all about this. I know it's an agreed motion, and but I still wanted to kind of get a feel for what's going on, and then also have a couple questions. So why don't you guys kind of explain what's going on?
Yes, Your Honor. This is fortunately a case that's not in litigation. The only dispute right now is between the parties on the amount of loss. And under State Farm's policy, when the two appraisers cannot agree on an umpire, they are supposed to go to court to have the court appoint one. The policy also has language in it about, I'm sorry, did you have a question?
No, go ahead.
Okay. The policy also has language in it about who is qualified to be appointed as an umpire. In this case, it needs to be someone who's licensed or certified as an engineer and architect, an adjuster or public adjuster, or a contractor. And that language is in the policy. So this is, sometimes I've had courts, when there's different policy language, appoint mediators and things of that nature. This policy is a little different, that we're looking for someone that has, an adjuster, public adjuster background. And while I won't endorse all of the ones that are listed in the insured's list, they are all certainly qualified, as are the three individuals that are listed in ours. I know Ms. Nasworthy has an objection to Mr. Anderson because it looks like recently he did an appraisal for State Farm. I'm willing to remove Mr. Anderson from consideration, but any of the five that have been submitted to the court are certainly qualified. I would point out Shannon Cook. Mr. Cook used to be Steve Mostyn's appraiser. He was the one that Steve Mostyn appointed. So to suggest that he has any leanings towards insurance companies, I would disagree with that based on his prior experience. But that being said, we have seen that he can be a very fair umpire, and that's why a lot of State Farm appraisers have chosen him. And Mr. Semino, who is also, he's with Ingle Martin. He's an adjuster. He's done umpire work. I can't speak to having worked with any of the ones that are on the insured's list. But like I said, all five, if you exclude Mr. Anderson, are certainly qualified under the policy. We just need the court to select one so that the parties can move on with the appraisal.
Okay, response?
Yes, Your Honor. I agree that that we are looking for someone who has those the three qualifications that they're talking about. State Farm didn't mention in their petition or their motion to appoint umpire about the impartiality and the, like I said, like I had talked to Mr. Schumacher, Mr. Anderson, I gave him two examples of where he had done recent appraisals as a State Farm appraiser. And it's my understanding that Mr. Semino also does appraisals for State Farm. He works for Ingle Martin, which Ingle Martin owns Eberls. Eberls is one of the four catastrophic insurance appraisal firms, independent firms, and they do about $100 million a year worth of work for State Farm. So I would say that Mr. Semino, who, by the way, I've requested and never received a copy of his resume or CV. And I had not been able to find out anything about Mr. Cook. So I don't know that he has ever done claims as a adjuster for State Farm.
So I'm looking at your motion, Ms. Nasworthy, and am I saying your name correctly? I apologize. I don't mean to butcher it.
Yes, Nasworthy.
So I see that these three folks have been submitted by you, Mr. Bostic, Mr. Castles, and Mr. King. And Tony, if you look at the screen, then you can see the spellings. of those. And then, but I don't see where is the list from the State Farm?
It's on their motion.
Oh, they have a motion too. Okay, it's not here.
It's the application, Your Honor.
Oh, the original app is here?
Yeah.
Okay, it's in there. Okay. Okay, so let me just ask this. I'm not familiar with any of these people. And so, and we don't appoint a whole lot of umpires up here. At least I haven't over the years, maybe one a year. And I usually do appoint an attorney or a mediator. So I'm not familiar with any of these folks. So what I'm going to do is I'm going to have each of you guys veto 2 people from the other side to narrow it down to 1 per side, and then I'll pick between those 2. So, and you vetoed first, Ms. Nasworthy. You vetoed that gentleman who had done all the work for State Farm.
Mark Anderson, right.
Yeah. So why don't, Mr. Shoemaker, why don't you veto somebody from the other side? So we're going to go back and forth.
Sure. Let me, I've got her list. Let me pull it up real quick. I would veto Castles.
Okay. Now you get to veto Ms. Nasworthy. No, we'll do this as what?
Semino.
Semino. Okay. And then Mr. Shoemaker.
Mr. King.
Mr. King. So who's left?
Chess Bostic on our side.
What, one at a time? Bostic and who?
Shannon Cook.
Shannon Cook. Okay. Each of you guys make a 30-second presentation. Ms. Dean, if you could go ahead and record them on why you think your person should be chosen. Ms. Nasworthy?
Mr. Bostic is a public adjuster. He does fit one of those. I'm sorry.
Go ahead.
Okay. Mr. Bostic is a public adjuster. He's done a lot of work for as both an umpire and an adjuster, and he's been in business for a long time, and public adjusters have to be licensed by the state of Texas. And so I just think he's qualified.
How many times has your firm worked with him as an appraiser?
Normally, I only get involved on these when they can't agree, but he's been appointed on several occasions. And he also is one that the appraisers often agree on.
Okay.
They don't have to come here it's only when the appraisers can't agree.
All right. Response?
Sure. Shannon Cook, like I said, he used to be Steve Mostyn's, the appraiser that Steve Mostyn, who is, I don't know if the court's familiar with, but very well-known plaintiff's attorney.
I'm familiar with Steve Mostyn, yeah.
Yes. Shannon Cook was the appraiser that he used on all of his appraisals. Since that time, he's focused more on umpiring. I've seen a number, he has been an umpire. I'm not aware of him ever being an appraiser for State Farm, but he has been an umpire on a number of State Farm claims. Sometimes he sides with the insureds, sometimes he sides with State Farms. The response that I've gotten from the appraisers that State Farm works with is they feel that he at least can be fair. I'm not very familiar with Mr. Bostwick. So
Bostic.
He is a public adjuster. That doesn't immediately exclude him, but obviously public adjusters spend the majority of their time doing work for insureds. But like I said, Mr. Cook has done a lot of umpire stuff. We've seen that he can be fair, and I'm not aware of any case where he has done work as an appraiser for State Farm.
Mr. Bostic, where is he located? You just have a 188 number. I don't know where is he?
I have his resume attached. I'm sorry.
He is located in Dallas.
Yes.
Okay. And where is this property located?
It's in Sunnyvale.
So in Dallas County?
Yes, sir.
I'm just going to go with the closest person. So Bostic is in Dallas. The other guy's in, I guess, Huntsville. And so I'm assuming Mr. Bostic will be more familiar with Dallas County. And so I'll go ahead and appoint Mr. Bostic. So is there an order in here that I need to?
I thought thought I attached one when I filed my motion, but I may not have.
Is it maybe attached to the motion? Let me see. They should separate it, or it should be separated.
Each clerk is different and some of them want things attached and I'm still trying to.
I don't, here, let me show you. I don't see an order in here.
I don't either.
Okay. Do you mind emailing me, and you can detail in here to two things I'd like you to add in the order, Ms. Nasworthy. One is that on April 2nd, which is today's date, 2021, the court heard motion to appoint an umpire. Just make sure you put today's date in. It makes it easier for me to make sure I get it done correctly. And then second, though it's not as big a deal in this case because you've only had one motion. And then the second thing is if you could just detail what I did. I let each of you veto two people and I just chose between the two that were remaining. And anyway, anything else? And if you could email Rhonda, my court coordinator, as well as e-filing that order. Does that make sense, Ms. Nasworthy?
Absolutely. I will do that.
And if you could get it to me today, that'd be great. I'll be back in the office early next week, but if you can't, that's okay too.
To you this morning.
All right, great. Anything else we need to chat about, guys?
No, thank you, Your Honor. I appreciate the time and consideration you put into this.
All right, you guys be safe, okay? And let me ask you a quick question. Do you foresee that we're going to be seeing a lot more of these types of matters in court because of the ice storm? I've heard people say that, but you guys are more in the field.
Absolutely.
You think?
Yeah,
I believe we are.
Yeah, there's certainly the claims. There's certainly a lot of claims with the pipe bursting. How many of them will go to appraisal? Probably a lot, just because that's what tends to happen. And hopefully, they stay out of court except for things like this. But I'm sure it's inevitable that a lot of them will, that there's going to be a swell of litigation related to them. But yeah, no, I do know that the days after the storm, at least our client was inundated with broken pipe claims, and we're working long hours to get people out in the field and to get stuff working on that. So it was a very unfortunate impact from the storm.
Let me just mention something that was mentioned to me by an attorney here in town, not involved in a particular case, but just generally on this issue. And the issue that was raised is this, there's not very many women or minorities that are, appointed as umpires. Apparently, I don't know if that's correct or not. I haven't appointed that many umpires over the years. And I usually do appoint women and minorities where I can. Have you guys looked at that issue at all and said, like, hey, look, we need to make sure that we have some diversity in the pool of people that can be appointed to this?
Your Honor, I would say that this is a rather unique niche of the law. I have a full-time job as an assistant city attorney in Grand Prairie, and I'm just doing these motions on the side. And
Okay.
I don't know of any people who are minorities or women who have the qualifications, but I will definitely look for that.
Okay, this is something that may get raised if you have in Dallas County, if you have this come up. It's already been raised to me, so I'm not fussing with you. I'm just raising the issue because I do think you'll hear it from others as well. So just kind of be aware that you may have to deal with that issue, the issue with diversity. So which is an important issue. All right, guys, thank you so much. You guys be safe and just give me that order, okay?
All right.
Thank you.
Thank you, Your Honor. Have a good day.
You too. Woolridge versus Global Site Location Industries. Is Mr. Dubiel? I think I saw him on the line. Is he here?
I'm here, Your Honor. Good morning.
Good morning. And then we have Mr. Grosso. Is Mr. Grosso here? Mr. Grosso or someone with Mr. Grosso's office? Anyone here for that? Mr. DeBeal, do you expect the other side to be here?
No, I attempted for my certificate of conference to have a conference, but wasn't able to pull that off despite multiple attempts. So I'm not expecting any participation really.
Okay. Well, we keep having people show up. Let me see. Okay, we've had a number of additional people show up. Is there anyone here representing Global Site Location Industries? Okay, Tony, are you ready?
Yes, Judge.
Let's go on the record on cause number DC 1919044. Council, make your appearances.
Your Honor, John DeBeal for Kimberly Wooldridge.
Okay, and we're here on a motion to compel, is that correct?
That's correct.
And do you see anywhere on the screen, if you could look through your opposing counsel? There is one person, a Taylor Tipton, I guess. Is that possibly they're having a problem connecting to audio?
No, is the only person I've seen or communicated with regarding this case is Mr. Grasso.
Okay, well, let's go ahead and proceed then.
So, Your Honor, this discovery was served with the petition in this case, and it's coming up on it was due back in April of 2020. And so we're set for trial at the end of this month. We had actually filed a motion for summary judgment, which Your Honor granted in part. And I have not received that order back from the court. So just to be safe, I wanted to have this order in place. And if the defendant is going to participate in this case, I'd like to get the discovery that was served back in March of 2020 and is coming up on the 1-year anniversary due date. So I've received no responses and would ask the court to compel those responses per the rules.
All right, so a couple things. So you said there was a summary judgment. When was it heard?
February 28th, I believe.
And is that this one that's on the screen? This would be the order for it?
Yeah. Yes, Your Honor asked us to submit a partially summary judgment, which I did. I wasn't able to get Mr. Grasso to communicate with the substance of that order, so I filed it with a cover letter.
Is it this order or is it a different one?
It should
That's
be
a final.
partial
So.
summary judgment.
Okay, where is the order? I apologize. I don't see the, is this the order?
That's it. That's
Okay.
it.
I thought I signed that one. Let me see. Is it not signed? Yeah, we mailed that out back on April 1st. So I guess you haven't gotten it yet, but I have signed it.
Okay, great.
Okay, so have you submitted an order on this one?
I believe it was attached.
To the motion to compel?
Yes.
Let me see.
Well, filed as a separate lead.
I don't see it. Do you see it in here somewhere? Yeah, I don't see an order.
Well, my apologies, Your Honor. I'll get that filed today.
Okay. All right. So go ahead and so just so we're clear, go ahead and try to email me, email my court coordinator this on the order. Make sure that you include that it's on April 2nd, 2021, that this was heard, that the defendant did not appear for the hearing, and try to get that to me this morning if you can. If not, definitely by this afternoon.
I'll get it to you this morning.
And make sure you e-file it and email my court coordinator.
Will do. Thanks so much, Your Honor.
All right, anything else?
That's all.
Okay, thank you.
Thank you.
Okay. We have a lot of people showing up here. Are both sides here on the Lenahan Law Firm versus Huffsey case?
I believe we are, Judge. I saw Mr. Marie. There he is.
Here, Judge.
Okay. Okay. All right, Tony, let's go on the record on cause number DC 2018255, Lenahan Law Firm versus Hufsey. Counsel, make your appearances.
Your Honor, Tom Coward for plaintiffs Lenahan Law and Gonzalez PC, along with Mark Lenahan is here as well.
Sorry, Eric Marie for defendant. I forgot to unmute.
Yeah, just stay unmuted during the hearing. That'll be easier. All right, we're here on a motion to quash. Is that correct?
Yes,
Yes,
sir,
sir.
Judge. It's our motion. The defendant noticed 3 depositions without agreement to the dates. We filed the motions to quash. The motions to quash are obviously based on scheduling issues. I mean, we filed a supplement yesterday that outlined the scheduling issues that I have. I've got a grievance committee meeting that conflicts with one of the depositions, and then an appellate brief due on the day of the other 2. But more importantly, Judge, we also asked for a protective order in this case on the discovery issues. Part of what we're struggling with, this is the case we were in front of you last week on the motion to transfer. It's a question of the division of the fee in a wrongful death case owed to Mr. Steve Schultz's estate after he worked on the case for about 4 months back in 2018 before his health deteriorated and he was unable to continue to practice law. One of the issues here is that the parties disagree over what exactly the measure damages is going to be. How do you measure the fee, the division of the fee that Mr. Schultz's estate would be entitled to? We believe the law is unambiguous about that. It's a reasonable hours times a reasonable hourly fee times the number of hours, valuable hours worked. Plaintiffs or defendants haven't given us the measure of damages that they're going to seek. The pre-trial when we did, or pre-suit when we had an aborted mediation, if you will, it lasted for about an hour before defendants walked out. They were going on a contingent fee portion, which isn't permitted by the law. So on the protective,
these are settlement discussions, Judge, and I don't think they're appropriate for a hearing.
It's appropriate to mention that y'all, that we had the mediation and it wasn't successful.
These
because
are confidential settlement discussions, Your Honor, and I don't think they're appropriate for a hearing.
Let's just move on, Mr. Coward.
So the point being, Judge, that on the protective order issue, there's 2 elements to that essentially. One is the what's appropriate. I mean, obviously, what's appropriate in discovery is defined by the pleadings and by the law that applies. The other issue is the defendant has implied that they're going to try to make accusations in this case regarding the formation of the original attorney-client relationship that has no basis in fact whatsoever. What we would ask you to do, Judge, is, we need to know what their measure of damages is so we can know what the what's appropriate in discovery. And one way to short circuit that is to require the parties to brief that issue and present it to you for determination so that we have some guidance about what exactly we're talking about in discovery. So
who are the 3 people they're trying to depose?
Nash Gonzalez, who was the originating attorney in the case from Gonzalez. He's the principal for Gonzalez and Gonzalez PC. And then they sent notices for the parents of the teenager who was killed in the crash. So the original clients, the underlying clients, Benny Gamble Sr. and Rashika Walton, the mom and the dad, or the dad and the mom. So those are the 3 deponents that they noticed that we've quashed.
Okay, and why do you need those?
I guess you're asking me, Judge.
Yes.
Well, obviously, there's been a declaratory judgment filed by Nash, Gonzalez, and Lenahan. We answered, and I've alleged quantum merit period because Steve got sick during his representation. And under quantum merit, I don't believe Mr. Coward is correct on the law. The only guidance the court has is quantum merit should be a reasonable fee for the services provided. One of the very difficult things that I would have to address this morning is this issue of barratry. Steve confided in me that he thinks that this case was run by a runner. Obviously, under the Penal Code 38.12, it's a third-degree felony. And under the Government Code, there's a civil cause of action.
Have there been criminal charges filed on this?
Absolutely not.
Okay.
The problem is, Judge, under Government Code 82.065 and 0651, should the Gambles figure out that this case was run and that they have a cause of action, that cause of action would accrue to my clients as well. And they would be forced to disgorge fees and expenses, which, let's say, if we had settled the case, they might have already spent. And so my concern is that we somehow settle this case and then my clients get sued under the Government Code for fee disgorgement. I don't think how an attorney gets a case. I can tell you exactly how I've gotten all of my big cases, death cases, and I don't have a problem in the world doing that. I don't understand why this is such a sensitive topic, unless there is some fire behind the smoke.
Have you pled barratry at this point?
I want to do that's a pretty serious allegation, Your Honor. I can, if that opens up discovery to this. I don't know that I have enough facts. I want to do my due diligence before I accuse an attorney of a third-degree felony. I'd prefer to do my due diligence. It's a 5-minute question and answer, Judge. How did you find your attorney? If she says, oh, a friend of mine referred him, hey, that's fine. If she says, well, I was approached in the hospital and a guy gave me his business card, that's going to be a problem. And I think given how much of that there is in this business, I would hope that the court would have a similar interest in trying to figure out how the case was procured. Not procured, I don't mean to put it that way, but
Judge, there's nothing to support any of this. It's a pure fishing expedition. And I would point out, Your Honor, that the hospital that he's referring to is in Ardmore, Oklahoma. This collision occurred on I-35 in Oklahoma. So apparently defendant's theory is that a lawyer from Dallas, Texas has runners in Ardmore, Oklahoma. That's absurd. It's purely absurd. He's got nothing to base this on.
Also, maybe I'm misunderstanding the chronology here, but didn't Schultz have the case first? I mean,
no, sir.
Okay, so how did this work?
Mr. Gonzalez was retained by the family. And then he had filed the case originally with another lawyer out in Parker County. And then they discovered that one of the defendants was headquartered or based here in Dallas. So they wanted to switch the litigation to Dallas County. And at that point, Mr. Gonzalez got Mr. Schultz involved. They filed the suit here in Dallas and then in April, and then Mr. Schultz went down in June.
And so Gonzalez found Lanahan then, or how did they get to Lanahan?
Yes, sir. And there's a history there. I represented Nash Gonzalez in his appeals down in Austin back in the 13 through 16, 17, something like that. And have known Nash ever since, known Mr. Gonzalez ever since. And so Mr. Gonzalez is a personal injury law lawyer as well. So we practice in similar areas. And so when Mr. Schultz went down, Mr. Gonzalez referred the case to Lanahan Law. And Your Honor, one other issue just to point out to you on the protective order issues, the litigation's ongoing still. And you may remember from the motion to transfer, Judge Greenberg granted a summary judgment on this case. That is pending on appeal now. Our appellant's brief has been filed. We're waiting the appellee's brief.
Oh wait, remind me again, he granted a summary judgment on what?
There were two sets of defendants in the case, Your Honor. There was the original defendants who was the bullet driver, if you will, the distracted driver, maybe a better way of putting it. This case, the underlying case involved a situation where the Gamble's teenage son and another gentleman named Mr. Miller were changing a tire along I-35 in Oklahoma, and a driver on a cell phone came along and struck them, distracted by the cell phone call, and killed them both.
Well, what I guess I'm getting at is the summary judgment wasn't.
It was.
Am I getting feedback here?
Yes.
Do you guys have your sound on? Okay, I don't know why I'm having feedback. Okay.
So Your Honor,
Was the summary judgment in this case or in the underlying case?
in the underlying case, Your Honor.
Okay. And
So
so
there's
there's no
two-
settlement in the underlying case?
There is, Judge. There were two sets of defendants, if you will. There was the distracted driver, and then there was the remote caller, if I can call it that. So we resolved the claims with the distracted driver and responsible parties through her. Judge Greenberg granted summary judgment as to claims against the person who was on the other end of the cell phone. And that issue is up on appeal now. So, we're hopefully getting the case back. So, we have concerns about going too far afield in this case now because of the pending litigation. If the measure of damages is as we say it is, which is a reasonable hourly fee times the reasonable hours, then all the discovery focuses on Mr. Schultz and really doesn't impinge on our clients and their claim or our work product. If, on the other hand, it's just a reasonable fee compared to everything in the case, well, then it opens the door essentially to everything. And there's real concerns about disclosure of confidential information in the course of discovery in this litigation. We have concerns about that. And again, Judge, our position is that you ought to require the parties. Mr. Marie's first statement was he doesn't agree with me on the law. Well, let's figure out what the law is that applies. I mean, the pleadings are plain. There's no barratry in the pleadings. That's a naked fishing expedition. Let's figure out what the law is so you can tell us what's appropriate for discovery in this case. And that would just be you setting a schedule for us to submit competing briefs on the issue and make a ruling so we can go on from there.
Judge, some background, if you don't mind,
Go ahead.
briefly. There are actually two other severe injury cases that somehow Nash Gonzalez, who doesn't advertise, never seen him in court, is not a trial lawyer by his own admission, has, that Mr. Schultz was assisting him with. He has obtained other representation, and I was contacted, and she asked me if I wanted to come on as the trial lawyer on one of those cases. So there's two other cases, and I obviously refused. There's two other cases that we're probably going to include potentially with this one. We may be amending our pleadings to bring those two cases. I've never done this before, where there's been
So I'm a little unclear, Mr. Murray, what you're trying to do here. So Mr. Schultz got this case from Mr. Gonzalez, but you're trying to argue that Mr. Gonzalez may have committed barratry and that would knock out everybody's fees. Is that what you're saying?
Yes.
But nobody has made that allegation in this case.
No.
All right. Based on that, then I'm going to grant the protective order. I don't see there's any basis for this. So, so what else do we have for today?
Judge, so on the protective order issue, there's one other aspect to it, and that goes to the client's depots as a whole. I mean, our position is that they really aren't qualified to testify about the value of Mr. Schultz's work. What they know is minuscule in comparison to what the actual evidence will be. They both
so, Mr. Power, what would you suggest as to the proper? Mr. Murray has the right to take, do discovery and take depositions. If it's not them, then who should he take?
Well, the evidence is really.
Would it be Mr. Lanahan? I mean,
well, it'd be Mr. Gonzalez. Eventually, he'll get Mr. Gonzalez's deposition because Mr. Gonzalez was involved in involving Mr. Schultz in the case and was working on the case at the time, alongside Mr. Schultz. Our involvement in the case came after Mr. Schultz stopped working on the case due to his health conditions. So we have no knowledge about what he was actually doing. We can look at the file like anybody else can, any other lawyer can, and look at his work product, but that's really where it comes from, judges, the file, the written documentation.
So why don't we allow him to take Gonzalez's deposition just on the issue of what work Mr. Schultz did? Why don't we start the discovery there?
Yes, sir.
There's no question that's going to be relevant.
The only issue, Judge, is that they're making these allegations that Steve was already medically compromised before he got sick, which I believe was sometime in June of 2018. It's my understanding that Steve met several times with both Benny Gamble and Rashika Walton, who are the underlying plaintiffs. So I just need to know, their opinion obviously is going to be the most relevant opinion as to what type of competency they felt like Steve had. I don't anticipate these depositions are going to be any longer than 10 minutes, 20 minutes at most.
Judge,
And I
on
could
that,
probably do them over Zoom.
the medical records will be the best evidence of what his health condition was, not the lay opinions of the clients based on, you know, at most several hours of interaction with Mr. Schultz. The other problem is that they live out of state. Mr. Gamble has always lived up in Michigan, and I believe Ms. Walton is now in Georgia.
You can do it over Zoom. I agree with, okay, so I do agree with Mr. Murray on this, that I do think you should be allowed to question them on this topic. So I'll allow the depositions to go forward of them as well, but only on this topic. I don't want to get into this bear tree stuff if you have no evidence. It's almost like you're trying to pull a grenade, the pin on a grenade that everybody dies. That's not how this is going to work. And so you have no evidence of it, and it's your client that you're accusing it. You're basically accusing your client of also participating in a felony, although he's passed away. So I'm not allowing you to go into that issue. I don't think that's appropriate at this point. And so I will allow these depositions to go forward on the issue of Mr. Schultz's work and that alone.
Okay.
They're all to take place remotely.
And
All
then,
right.
Judge, on the scheduling, are the dates that are
No, you can pick a date. What date are you available? Give him 3 dates right now, Mr. Coward, that you're available.
Oh, Lord, Judge, I apologize. I don't have my calendar in front of me to know for sure. And I'd have to get a hold of the clients as well to confirm their availability. But
Why
I
don't
mean,
how do you want to handle this, guys?
my preference would be just to order us to agree, and we'll find.
We'll figure it out, Judge.
Yeah, we can figure it out. Scheduling we can work on, Judge.
Okay.
Your Honor, if I may.
Who's
Mark
talking?
Linehan.
Oh yeah, sorry, I can't see you. There you are.
Yes, Your Honor. We believe that the value of damages in this case is going to be sizing up Steve's work, the value of his quality hours. Mr. Mari is implying that no, that needs to be compared to the value of our hours. Until that issue is resolved, we don't really know what the scope of the case is going to be at all. How can we put this before the court, Your Honor, of what the actual measure of damages are? Because that's going to define the scope for 100 battles ahead.
But Mr. Lanahan, no matter what, you're going to need to know the value of Mr. Schultz's work, whether that's standalone or whether you compare it to
Absolutely.
To y'all's work. And so allowing discovery on that issue, I think, is appropriate.
Oh, absolutely. We agree that discovery on Steve's work is 100% appropriate. But
and that's the only discovery I'm allowing at this point, is discovery about Steve's work, Steve's mental capacity. I'm sorry, Mr. Schultz's mental capacity, the work he did, all that kind of stuff. This is not, you're not allowed to go into anything about the work done by Mr. Lanahan. I just want to make that 100% clear. The only discovery that's going to be allowed at this point is about Mr. Schultz, his mental capacity, and his work that he did.
Judge, I'd like to point out that I guess Mr. Lanahan and his pleadings that's all he's talked about, is all the work that they did on this case versus the work that Steve did on this case.
If you want to try to take discovery on Mr. Lanahan's work, then I agree with Mr. Lanahan. Then we need to resolve this damages issue you raised before. I feel like you keep on kind of changing your position here, because initially you said you wanted to go into Bear Tree. I said no. Then you said you wanted to go into Mr. Schultz's work, and I said yes. Now you're saying you want to go into Mr. Lanahan's work. If you want to go into Mr. Lanahan's work, then I do agree with Mr. Lanahan that we need to resolve the issue of this work product. Or how do we measure the damages? I'm sorry, how do we measure the damages? So
I mean, these are
do you want to
discovery
do that
depositions.
first?
I'm just want to take discovery on all the issues that are relevant to the case. So I don't
Well,
disagree.
how do I know if that's relevant if we don't know the measure of damages? I honestly don't. if you're pleading quantum merit, then it has nothing to do with Mr. Lanahan's work. Has nothing to do with that. It's just the work that Mr. Schultz did. Unless you want to brief this and go through summary judgments on it, but I don't think at this point the work Mr. Lanahan did is relevant to this case at all.
I like the idea of briefing it, Judge.
Okay. I think that's what Mr. Cowart suggested to begin with, so we'll go back with it. All right, so we'll brief this issue. We're going to delay discovery, and once we figure that out, we will determine the scope of the discovery.
Judge, and I hate to bring this up, but can you give us a schedule? Can like 3 weeks from today? 3 weeks from today for I guess our brief, we would go first as the plaintiffs. And then
I think it needs to be in the form of a summary judgment. I mean,
yes, sir.
So file it, get it set. I'm going to basically, I'll abate discovery for 1 month. So if you can get me an order abating discovery for 1 month to allow the parties to move for summary judgment on this issue. It should be a fairly discrete legal issue. Shouldn't it just, what is the proper measure of damages?
Yes, sir. We can do that then. I'll give you the order. And I hate, Judge, one last issue. We were working on a scheduling order. This is not in front of you by pleading or motion. We disagree whether or not mediation is going to be required in suit. We would like to include an order for mediation in the scheduling order. Mr. Marie has indicated he doesn't want to include that in the scheduling order. Could you give us some guidance as to whether or not you expect us to put mediation in the scheduling order in this case?
I always put mediation in the scheduling order. It usually needs to be done 30 days before trial. But you said you've already mediated this.
We already mediated.
We mediated it pre-suit, Judge. And like I say, it was a failed mediation because it didn't last.
I tend to agree that mediation needs to occur on this case after the summary judgment is resolved.
And Judge, I'm just going to object once again, talking about confidential communications during mediation. I have a very different take on why the mediation failed, but I don't think it's relevant to what we're
That doesn't matter to me. The only point is, at this point, it's what is, you guys have a difference of opinion about the proper measure of damages. Once we resolve that, hopefully mediation will be easier.
I believe that's true, Judge. Thank you.
Fair.
All right, anything else, guys?
Not for me, Judge.
Thank you, Judge.
So, okay, you guys are excused. Get me an order on that, Mr. Cowart, that details that we're going to have a 1 month abatement of discovery, and then the parties are instructed, I guess, to file summary judgments on the issue of damages to be resolved by the court.
Yes, sir. I will.
I would get that out quickly because after that 1 month expires, then they're going to be allowed to start conducting discovery again.
Yes, sir.
All right, thank you, guys.
Thank you, Judge.
Oh, and when
Judge,
you
real
file
quick.
that, I'm sorry, Mr. Cowart, when you file that, make sure you put today's date on it, make sure you share it with opposing counsel, and then try to file it as agreed as the form order and get that and email it to my court coordinator as well as e-filing it.
Yes, sir.
Judge,
Will do.
brief clarification in your order. Do you also want that the 3 depositions will go forward over Zoom over the matters that we've discussed today?
You can say that they're going to, I mean,
After the month.
I'd offered that, but then you said, no, you didn't want to do that. And you wanted to brief it first. And so.
No, yeah, after the month, I get the depositions is what I'm saying, Judge.
Well, but then we got to set the summary judgment motion and get that ruled on. If we can get all that done in a month, I think it's premature to start talking about scheduling depots before we can get the summary judgments even filed, Judge.
I would say that I would order that the depositions will take place over Zoom at some time, because I do think that no matter what the measure of damage is, these people need to be deposed. It's just what the scope is. So yeah, I'm fine with after this to order that after the summary judgments are decided, that these 3 folks will be deposed on the issue of damages over Zoom.
Yes, sir.
Okay.
Did you get that?
Yes, sir.
All right. Anything else?
No, sir.
All right. The next case I believe we have is ARM Energy Management versus Medallion Pipeline Company. Anyone here on that case?
Yes, Your Honor.
Who's here for that?
Yes, Your Honor. Richard Howell and Amy Baird from Jackson Walker.
Okay.
Also with me today are Dave Cook and Gabe Newley, who are in-house counsel for RM Energy. And we also have two witnesses, Michael Christopher and Scott Wishoff.
Okay.
Morning, Your Honor. This is Tom Patterson with Sussman Godfrey. My colleague, Mr. Downs, is here with me today. And Medallion representatives here are Mr. Mike Lassman, the Vice President of Marketing, and Mr. Brock Degater, who's the General Counsel.
So have you guys already been to mediation on this?
Yes, sir.
On
And it
Wednesday.
did not succeed?
No, sir. We mediated with Judge Ginsburg on Wednesday afternoon. And unfortunately, we were not successful in resolving the dispute.
I only have 10 minutes scheduled for this. Are we going to be able to get this done in 10 minutes?
No, sir. I believe we had asked for a half day, Your Honor, to address the TI hearing, which you had set for today.
Yeah, I don't have a half day today. I have 10 minutes. Did the clerk tell you could have a half day?
Yes, Your Honor. We discussed it with you during the TRO hearing on Tuesday.
I did not give you a half day.
Okay.
So under the emergency orders of the Dallas District Courts, we're allowed to order parties to submit affidavits or depositions in temporary injunctions. I think I'm allowed to do depositions anyway. So I'm not going to have time to be able to do this as a full-fledged hearing today. I know that there's some time constraints on this. How quickly could you get depositions done?
Well, you originally set the TRO order for just to last for just 3 days
Right.
rather than 14. My suggestion would be that you would extend the current TRO for 14 days, and we would conduct just depositions during that 14-day period and then submit to you briefs and deposition excerpts at that time. It would still be well within the 28-day period that's contemplated by Rule 680 and 683. So that would be my suggestion. I think our preference would be to have a TI hearing with you, but we understand that in light of your concerns about timing, that we could do it another way.
Mr. Peterson?
Connor, is there a time perhaps next week when you would be available to hold the hearing?
Let me see.
Next week or, yeah.
Well, on Tuesday, I do have I have a number of jury trials that are going to be reset, but I do have one non-jury. I'm not sure what the status of that, if it's going to go forward or not. So that could wipe out my week next week. I just don't know. It's been a pretty hotly contested case. Let me see if they filed anything. They haven't filed anything, so they haven't filed a continuance. Can you go grab
Presumably, you could
Rhonda?
extend it as long as the 16th. So if the week of the 12th would work, that would be fine, I think, as well under the rules.
What I'm going to do is have my court coordinator call the attorney on that trial and just see how long it's going to take. And that would help make that determination. Because if that trial is going to be short, if it's going to be a day or a half day, then I can fit this in on Thursday potentially. But if it's going to be all week, then that's something else I need to figure out.
I don't want to speak for Mr. Patterson, but I think if we could have it heard next Thursday, that would be ideal.
So there is a case, let me show it to you real quick. It's the Intom case. Yeah, can you call them and ask them how long they anticipate trial's gonna be? Just get anybody on, like I don't need a hearing with them. I just need to get an estimate of time. If they think it's gonna be a day, an hour, a week, I just don't know, because we haven't had anything recently on them. And just because I'm just trying to figure if I can schedule this. Okay. All right, let me, once I hear back from them, then we'll go from there. So,
Your Honor, may I raise one issue?
okay.
My understanding during the temporary restraining order hearing was that the reason the court, in looking at the evidence and the arguments of counsel, the court found that it didn't appear that the October 5 letter that they had sent to us, to Medallion, provided us with notice put us on notice of default, which would have then, if it had, would have then triggered their right to attempt to terminate, which they did this past week. My understanding of the reason why the court extended or entered the TRO was because they had they represented that we were secured we had credit assurance through today with a guarantee with Glencore's parent. We dispute that, but in any event, that doesn't matter. That guarantee expires today, and we are at risk. And so
the TRO would expire today.
Yes, sir. Yes, sir. And
Your Honor, we don't believe the TRO should expire today. We're prepared to go forward with the TI hearing, and we don't believe that we believe a TI should be issued. We certainly understand that the court has other scheduling conflicts, but we think that in order to maintain the status quo, the appropriate thing to do, if we're going to get reset to next week, is to extend the TRO for those 4.
Let me just say this. I kind of went, I feel like Mr. Howell, a little bit out on a limb for you guys to even extend it to today. I don't think that that letter was notice. And so my inclination was, my hope was is that you guys would settle this, which I think would have been the wiser course, to be honest. And I kind of gave you the benefit of the doubt, and also try to give you a chance to settle this by extending it even to today. I kind of agree with Mr. Patterson,
sir.
Patterson, that, that was a close call, whether or not they were properly secured. So my intention would be that the TRO would expire today. I understand you want a temporary injunction today. I don't have time. And so, and I don't see a basis to extend it. I just don't have, I went out on a limb to give you a chance to try to settle. And because I thought there was a reasonable argument that it could be extended to today, but I don't see any basis to extend it. So if Mr. Patterson wants to agree to extend it, I have no problem with that.
I can't agree to extend it, Your Honor. We appreciate that, and we will. I think that will moot the issue of having a temporary injunction hearing for the relief that's been claimed.
Your Honor, it will moot the issue because it will cause us irreparable harm. And we have our CFO sitting here ready to testify about what the nature of that harm is, as well as our senior vice president about the effect it will have on our business and our employees. And, we have, I think, tried to bend over backwards to Mr. Patterson's client to demonstrate why these LC's letters of credit should not be drawn upon. And if we are going to delay the hearing of this issue, you would be causing us irreparable harm by terminating the TRO today.
I'm not the one causing irreparable harm. The fact that your attorneys.
I apologize. I don't mean to suggest that.
I'm really,
but
it's kind of one of
Mr.
these no good deeds goes unpunished. I really went on a limb to even extend the TRO to this point. I gave you an opportunity to mediate it. I didn't write that letter that should have been provided notice and should have cited. And I'm not the one who decided not to respond to the letter that said, hey, look, we don't think this is notice. You need to tell us it is. And so to say that it's the court's fault that that this is happening is I think extremely unfair.
No, sir. I apologize. That's
Mr.
not
Howell,
what I was trying to
I'm really
suggest.
surprised you would say that.
Your Honor,
yeah.
First of all, I apologize. That is not at all what I was intending to apply. What I was intending to imply is that Mr. Patterson's client, Medallion, is aware of the consequences of the drawing on the LC to our business. And if the TRO hearing is going to be delayed, it will cause us irreparable harm. May I very, very briefly, Your Honor, in 2 minutes, explain why I believe you should revisit your finding about the notice letter and why.
I already looked at the notice letter extensively. I've read the whole notice letter. I've read the provisions. I don't think that was proper notice. I'm not 100% sure that they were fully secured these last 3 days, but because it was, a close call, I extended it to today in hopes that you guys would kind of see the lights, that they would and try to settle this. And I never told you that you had a half day, as Mr. Howell, and then the fact that you blame me because of all of these issues, I find it a little bit upsetting, but I'm not trying to give you a hard time, but this is a problem of your client's making.
Your Honor, respectfully, again, I apologize. I did not mean to suggest that this is a problem of your making at all. It's a problem of a commercial dispute between Arm Energy and Medallion. Mr. Patterson sold you on a story that after we sent the October 5th letter, there were crickets, that we never made any response, or there was never any follow-up from our side. That's patently untrue. We have the emails to show that that's untrue, and to show that Mr. Lastman, who's here to testify for Medallion, repudiated their obligations under the agreement by saying they will never be able to perform. And that all occurred between the time of the October letter and the time of the termination in March. There was significant correspondence between the parties regarding a request for a cure and a request for a remedy. The letter specifically requests.
Why weren't these emails included in the TRO record then?
Well, Your Honor, we believe the TRO record was sufficient at the time because of the declaration that was attached to it by our officer about those cure efforts. You asked us questions that were very good questions at the TRO hearing about what efforts followed that. And so we've provided an exhibit list with the court for our TI hearing. Mr. Patterson and I have discussed via email whether there are any objections to our exhibits or his, and there are none. And those exhibits show multiple follow-up efforts with Medallion and with Medallion's partner, a company called Epic Pipeline, to try to secure relief. And what I can tell you is that in November, in December, in January, and in February, there were repeated efforts to secure relief, and we were told no on the two primary issues that are in default, one of which is the failure to provide a million-barrel vessel, and the other is our ability to use the WTL, which is a particular grade of crude oil. And literally, Mr. Lastman, who is on this call right now, said Epic and Medallion will never be able to perform. That's a quote from him in his email.
But did you ever send them a notice letter saying, hey, look, pursuant to, and I don't remember the section number at this point, but pursuant to section such and such, you were put on notice and you have an opportunity to cure? Was that ever done? That was never submitted to me before in the TRO hearing.
Your Honor, in the October letter, it does not use the word cure. It does say there are several ways that Medallion can resolve this issue. And that's with one issue. With the other two issues, we also ask our requested relief is this. Our request is that Medallion do X. That is a request for a cure, even if the word cure is not used. We have also sent them a follow-up notice letter in March, identifying these defaults again, and notifying them that they're going to we're going to re-terminate. You can't repudiate an agreement, spend 6 months with the counterparty trying to get those issues resolved, and then come into court and feign ignorance about all of those communications, as Medallion did 2 days ago, and then avoid termination. They are also over-secured, Your Honor. What they are holding right now is $14 million in cash. And if they're able to go get these LCs, that's an additional $19 million. What they're entitled to on a monthly basis is $1.2 million. We have made all sorts of offers to say, look, we'll provide the extra $1.2 million, but we're going to terminate in April. Even if you don't think we properly jumped through every single hoop in between October and March, okay, but we're going to terminate again in April because after we go through every single one of those hoops, because whether we did it then or we're going to do it again, these agreements are coming down because of their breaches, and they are already holding 10 times more money than what they're entitled to, even before if the agreements are terminated in 30 days. And that's even before they go and get these LCs. And what's going to happen, Your Honor, if they go get these LCs, the $19 million in letters of credit, is it may trigger financial covenants with our financial institutions. It's going to impair our trade credit, meaning that our traders are not able to trade crude oil and natural gas for the amount of the LC that is now taken as debt on our balance sheet. And it's going to harm our business reputation. It's going to cause I think the testimony will show, a spiral effect on this company that will be far, far in excess of any financial damage. This is not about $19 million. This is about a tremendous looming irreparable injury to the company that may, I don't take joy in saying this, end arm. And so this is a serious issue, Your Honor, that we have taken seriously. And I just think you have been, I think, led astray by Mr. Patterson's comment about crickets, that there was no follow-up here, when the record that I think should be admitted, I think you can admit those exhibits because there are no objections to them, show that Mr. Lastman has said they will never be able to perform this agreement as promised.
Your Honor, respectfully, there was no notice. To answer your question, there was no notice. There was no notice until this week when they sent notice, and they have to give us the opportunity to cure. You asked, why didn't they include these emails? Well, first, they don't exist. And secondly, they wouldn't qualify as a notice of default under the agreements.
Your Honor, if I'm able to share my screen, I can show you.
Whoa. Let Mr. Patterson finish.
If they want to contend that Medallion draws on these LCs, which is it's right, because they've never argued that they could solve their problem if they had posted the additional letters of credit that are called for in the contract when Glencore terminated their guarantee, but they didn't. They had that option and they chose not to do that. But if they want to argue that Medallion was made the draw on these LCs improperly, they can sue us for that. But for right now, we have no guarantee. We do not have the credit assurance that these folks said they agreed in their contract we would get, that they haven't posted. We should be allowed to draw on those LCs, and the TRO should be allowed to dissolve today.
Your Honor, if I'm allowed to share my screen, I'll show you the emails that Mr. Patterson says don't exist.
Okay. Do any of the emails provide notice pursuant to the contract? I've already seen all this. I'm giving you, okay. Are you there? I can't hear you. I can't hear him. Is he muted? I can't hear him.
I apologize, Your Honor. I must have hit the mute button. This is an email from Mr. Lastman, who's here to testify today from Medallion. He's their senior vice president, to Scott Wishoff, who's our senior vice president. And Brock DeGuider is their general counsel. This is a follow-up. This is one of many follow-up emails that happened after the October notice letter. One of the issues in the October notice letter was the million barrel vessel. And what Mr. Lastman says is, regarding loading your full volume on one ship, which in the contract says is 1 million barrels, he says Epic, which is Medallion's partner, says they will never be able to load that amount. When the second dock is complete, they're required to complete a second dock for us under the contract. And they say, even when the second dock is complete, they will have the same issue. Epic's position, which again is Medallion's partner, is that the 1 million barrel language continues to be up to that obligation, a point that only attorneys can argue. So he's saying that one of the two most important covenants in the contract,
settled, okay.
one of the two
Also
most
show
important
D.
covenants in the contract is something they will never be able to.
Okay, all right. So I just got some information that was important. So the case that set for next Tuesday just settled, and so Mr. Patterson, I want to be fair to both sides here. I don't really, unfortunately, I don't have time today to do this, but the case that I was worried was going to knock you guys out for next week, I can hear this next Tuesday at 9:30. I'll extend the TRO to Tuesday. In the interim, I would like you, how much time do you need? I mean, can you do depositions? Is there a way to shorten this at all, or how long is this going to take?
We believe it'll take about 3 hours, and we believe our part of that is about maybe 2 hours. So if Mr. Patterson's going to take another 2, say at 4 hours.
Your Honor, frankly, Tuesday, I've got to go get my second shot next week. My travel is, I have to go to New Mexico to get it. I'll go into the reasons why. I go on Monday. I get my shot later in the week. I think the answer the question that never got answered is, there is nothing in these emails that provides the notice that they're required to provide, or he would have showed it to you. He would have showed it to you, earlier. And there are emails that say quite differently from what he's arguing here. So we would ask that the court allow the TRO to dissolve today and the parties move forward under their rights. I think you've been,
Mr. Patterson, so you're getting the shot what day, Tuesday?
I'm getting it at the end of next week, Your Honor. I have to travel to New Mexico on Monday.
Okay, well, you can do this by Zoom if you need to. Mr. Patterson, I'll give you two options here. I understand your position, but I do feel, given what Mr. Howell said about the severity of the consequences if I don't do this, either we can do the injunction. I have a limited amount of time this afternoon where each side is limited to an hour per side. Let me just ask a quick question real quick. So we could give you guys each an hour per side if you want to do that, Mr. Patterson, and we'll do it today. We'd start at 1:30 and go until 3:30. Each side would have exactly an hour to do their presentation, or we can do it on Tuesday and I can give you each 2 hours per side. I'll leave it up to you, Mr. Patterson.
We prefer this afternoon, Your Honor.
Okay. Mr. Howell, I would strongly urge you, strongly urge you, and I want to make it clear, I never told you you had a half day today. I doubt my clerk told you that. You have an hour per side. There's not going to be any extensions, so make sure you streamline your testimony and make sure you have everything ready to go. And we'll hear it at 1:30 today. But if once you finish that 1 hour, you're out of time, okay?
I understand, Your Honor.
All right. We'll see you guys back at 1:30.
Thank you, Your Honor.
High v. Shively. Is anyone here on High v. Shively? High v. Shively.
Yes, I'm here, Your Honor.
Who's here for that? I can't hear.
I'm here, Your Honor.
Mr. High?
Yes, can you hear me?
Yes. And then Mr. Bryson. Is Mr. Bryson here?
I'm here, Your Honor, on behalf of the movement. Can you hear me?
Yeah, I can.
Okay.
And Mr. High is now pro se. Is that correct?
Yes.
Okay. All right, Tony, you ready? Let's go on the record on cause number DC 1913135. Council, make your appearances.
Rance Bryson here on behalf of the movement. Brian Shively, Your Honor, the defendant.
Mr. High, state your name, please, for the record.
Billy High, I'm here on behalf of myself. I haven't had time to obtain adequate counsel.
All right, Mr. Bryson, you may proceed.
Your Honor, it's a personal injury case involving a car accident that was on the tollway. I noticed the plaintiff's deposition by agreement of his counsel on December 23rd. At the last minute, Mr. High canceled the deposition and didn't appear. We rescheduled the deposition by agreement on January 6th. At the last minute, Mr. Hyde claimed he could not sit for his deposition, and we rescheduled to a later date. The deposition was rescheduled to February 24th, 2021. At the last minute, Mr. Hyde claimed he could not sit for his deposition. And at that point, I didn't want to reset and reschedule a deposition a fourth time, Your Honor. So we did appear for that deposition with plaintiff's counsel, and I took a certificate of non-appearance. Since that time, plaintiff's counsel has withdrawn from representing Mr. High. Would ask that the court sign an order requiring Mr. High to appear for his deposition by Zoom on a date certain, so that I can develop the facts in this case.
Let me ask Mr. High. So according to the defense counsel, they say that you didn't show up to 3 depositions. Obviously, that's a concern because everyone took time out of their schedule to be able to depose you. So why didn't you appear? What happened?
I let her know. I let my counsel know, Tanika Mann, which she's not answering the phone. They're not returning any of my phone calls. They're not responding to any of the emails. I requested to reschedule 2 weeks before, and they didn't respond to the email. Right now, I'm being denied adequate counsel. Didn't get notice of the trial date. They denied me mediation. I didn't agree to a 6-person jury.
Mr. Hyde, just 1 second. So did that happen all 3 times? Because you said that you notified her 2 weeks in advance.
Yes.
Was that for each of the 3 deposition dates or just for one of them?
That was for the first rescheduled, and I only rescheduled twice, the January 6th and the first time. Those were my only 2 reschedules.
Well, he says there's been 3. Am I misunderstanding that, Mr. Bryson?
No, not on my behalf. That was my attorney's office rescheduling.
Your Honor, we noticed the deposition by agreement on February 24th, and just a couple of days prior to that, or actually, I think it was the day of the deposition, Mr. High claimed he could not sit for his deposition, and he'd asked for us to cancel and reset it, but I didn't want to have to reset it a 4th time, Your Honor. So I went ahead and appeared with plaintiff's counsel present and took that certificate of non-appearance.
So let's kind of look at the big picture here, which is you have a trial sitting on May 25th. You have, which will need to be moved, but we can talk about that.
Okay.
I do think you're entitled to take his deposition. I want to give him some time to be able to find a new attorney. And so, Mr. Bryson, and let me just give you one other piece of tentative information. This is not set in stone, but my understanding as of, April, this is a constantly moving target, but April 2nd, 2021 at 10:21 a.m. Let me just make sure I don't have any new emails on this issue. We have been given a trial schedule for this summer by our local administrative district judge, who has, let me see if we have anything new. So as of now, again, this could change, is the 68th will get it. I don't know if you've heard, but we are restarting jury trials in Dallas County on a very limited basis, starting on June 7th. And each court has been assigned a day by our local administrative district judge that will be able to try cases. And so at least as of this point, it's a little bit up in the air, I think. The week of June 22nd and the week of, I believe it's July 26th, are kind of the dates for the 68th. And so we could set you guys on one of those two dates if you'd like, or we can move it out farther, but it can't be on May 25th because you guys have requested a jury. And so, and we're not going to have a jury. Nobody will have a jury on May 25th. So Mr. Bryson, first I'll hear your position, then I'll hear Mr. High's position on this.
Well, Your Honor, I had submitted an order to the court requesting that the court order Mr. High, to appear for his deposition via Zoom on the 29th of April, based upon a Zoom link that we would send to him at his email address on the 27th of April. That would give him essentially almost 30 days to get a new lawyer in the case.
Mr. High, what do you think of that?
I think I may need a little bit more time, Your Honor. The problem is the Ben Abbott Associates, Tanika Mann, lead counsel, they kept scheduling the trial date without confirming availability. I'm a disabled veteran and I have extenuous appointments with my doctors. And she knows that, and they're not confirming availability before they set the trial dates.
Sometimes they don't have any. I'll be honest, sometimes given everything that's happened with COVID, they don't necessarily have a lot of input on this, though I do talk to them. I have talked to them the last couple of times about resetting this. But so what date would you be available to take the deposition? Give me a date so that Mr. Bryson can check his calendar. I don't want to interfere with any of your doctor's appointments.
Okay, Your Honor. If the trials move from May, is May okay for my deposition?
Yeah, that's fine. Just give us a day that you're available.
Towards the end of May, whatever you have on your schedule.
Give us a date that you don't have a doctor's appointment.
Okay, the 25th, the same date.
Mr. Bryson, could you do May 25th for the deposition? Are you available that day?
Yes, Your Honor, I can do that. Looks like I'm open that day. Well, actually, that's our trial setting in this case. So yes, I would be available because I had set that day aside, and obviously we are not going to trial on that date. So yes, Your Honor, I can do the 25th.
So go ahead and amend the order, Mr. Bryson, to say that it's going to be on May 25th. What time would work for you, Mr. High?
May 25th, Your Honor, anytime afternoon, 1 o'clock.
Would 1 o'clock work for you, Mr. Bryson?
Yes, Your Honor, 1 p.m. works good for me.
All right, and then do you want to go ahead and move the trial setting, guys, or do you want to wait until May 25th to do that? Or I'm totally up to you.
If it's okay with the court, I'd like to address that now while both parties are present.
Yes.
Okay.
I concur with Mr. Bryson.
So you have three options. We could set you the week of June, whatever, what did I just say, 22nd?
June 22nd and July 28th is what I heard, Your Honor.
Yeah, let me just double check. Because that keeps changing. So let me just make sure I have the dates correctly. Okay. So the 68th, let's see. I'm sorry, it's the week of July 19th or the week of June 23rd. Or we can just move it August or later. So whatever you prefer. I wouldn't suggest June because I want to give Mr. High an opportunity to get an attorney. And so I would say either the July date or later.
Right.
Yes, Your Honor, the week of the 19th of July works really good for me. Not sure about Mr. High.
Yes, that's fine, Your Honor.
All right. Can you go grab Rhonda for me?
And Your Honor, as far as if the, if the court would like to set it later in August to give us, more time to maybe to mediate, that's fine with me as well.
So let me just tell you what I know at this moment, which again may change. So I apologize if it does. I have no control over any of this, unfortunately, is that these first 2 months we're doing jury trials, we're going to be doing, we're going to be getting each basically the 68th, and all other courts will get 1 date a month basically to try it. I think in August we'll start going back, I think, to somewhat more normal schedule.
Okay.
But I don't know. So after those first 2 months, it becomes very uncertain on how we're doing this.
Okay. Well, then under those circumstances, I would agree to the July 19th week.
Mr. High, that works for you as well?
Yes, sir. Yes, Your Honor.
It's probably, I don't know exactly what day of the week. Right now it's scheduled for July 19th, but again, that could change. So it's could just be available that week, and we'll just kind of figure it out once we get closer to it. So this High case, we're going to set to the week of July 19th. And it may turn out we should do it on Monday. We may do it on Friday. We may do it some other day, depending on what exactly gets worked out. And again, this could change. The local administrative district judge has been moving stuff around. So, but that's what we have right now, and we'll keep you updated.
Thank you, Your Honor.
I'm sorry.
Thank you, Your Honor.
For the trial, correct. So, Mr. Bryson, what you need to do is go ahead and prepare an order that reflects this deposition date that we discussed. Go ahead and e-file it, as well as email my court coordinator. In your order, please make sure you include that this was heard on April 2nd, 2021, not on this date. It makes it a lot easier for me to track when what's happened. And any other questions or anything else we need to talk about? I do want you to go to the mediation before the trial setting, but you guys work that out.
Okay, Your Honor.
Thank you, Your Honor. I'll submit an order today.
All right. Thank you so much. You guys have a good day. Okay.
All right. Thank you, Your Honor.
Thank you. Angel Sword versus Watson.
Good morning, Your Honor.
Yes, Your
Morning.
Honor.
How are you? Okay. Let's go on the record on cause number DC 207334, Angel Sword versus Watson. Counsel, make your appearances.
Good morning, Your Honor. Jeff Henley for defendant Oksana Watson.
Your Honor, this is David Vassar for the plaintiffs, Angel Sword Corporation and Angel Sword LLC.
Okay.
Your Honor,
Yeah,
this is
one more,
Matthew
counsel,
Hill.
Your Honor.
Excuse me, Your Honor. Matthew Hill for third-party defendant Daniel Watson.
Okay, we're here on defendant's application for appointment of a wind-up receiver, I guess. So why don't we go ahead and proceed?
So, Judge, I've listened, I don't know if I'd use the word charitably, but I've listened to opposing counsel's exhortations that we need more time for presentation of evidence. We've allotted 30 minutes for this. He insists that we need more time. And so at his request, I was going to suggest that we try to reconvene in another 2 weeks or so for a 2-hour block of time, I guess 1 hour per side, as you seem to allocate to the previous parties. I always try to do what, is in vogue, I guess, Your Honor.
But let me just say this. I feel a little, so I've dealt with this provision before in another case. It was a much larger entity that was involved, or series of entities that were involved. I've always felt like for something like this, that you would really need a trial, a full-fledged trial, to make a determination if it should be wound up. I would make a recommendation. This is not an order. Is what I think is the wisest course. This is again not an order. Would be to appoint a receiver on this case, not a wind-up receiver, to kind of make a determination of, making sure that the assets aren't, wasted, and figure out what's going on and all that kind of stuff. And then the receiver would be in place. The business would continue, hopefully, to function. And then at trial, if the jury or myself, whoever the fact finder is, makes a determination that a wind-up is appropriate, then that person would convert into a wind-up receiver.
We're perfectly fine with that, Your Honor. That's very sage.
And Your Honor, we filed a response on Monday to the application. I think there are preliminary issues that need to be decided from the plaintiff's perspective. Those being whether the defendant even has standing to urge her application. I think a hearing with you for some time, there was no evidence submitted with the application whatsoever. We did submit evidence with our response. So I think the preliminary determination, as you know, Your Honor, they have to be an owner or a member. And I don't think that the defendant is going to be able to show that. I think you'll be able to decide that first thing. I also know that Mr. Hill, on behalf of the third-party defendant who was added just recently, their answer date was Monday, has a plea to the jurisdiction in this case. So I do think, Your Honor, that before we get to what the court has announced is its preferred way to handle things, which I don't doubt, we've both seen your TGI Fridays case on this issue.
How do you know about, is that because there was a Court of Appeals decision, or how did you know about
There was,
TGI?
Judge.
There is, Your Honor, and that's one of the few cases out there on this T-box section. But we really...
Did I get affirmed? I think I got affirmed on that, didn't I?
I'm pretty sure, yes.
Yeah, I think I did.
And so those preliminary issues are out there. I think Mr. Henley and I have, over time, agreed to at least continue what we believed was a 30-minute hearing. I heard from Rosemary it was a 5-minute hearing. The calendar list is a 15-minute hearing. I think we can both agree that even these standing and plea to the jurisdiction issues can't be covered today. And as Mr. Henley said, would like to push this off a couple weeks where you have at least an hour, perhaps two.
All right. Okay. I thought I probably wasn't totally clear on this. What I was saying is that I don't think a hearing is appropriate on this issue. I think it needs to be decided in a trial. That's how we did it in the, TGI Fridays case. I think that's appropriate. If I'm going to appoint a wind-up receiver, there's certain provisions that need to be determined from a fact finder. Let's see, when is your trial set on this case? Oh, your trial setting's the end of the month, so we could just hear this. Why don't we just hear this at the trial?
Trial setting's in April. I know there's a jury demand in defendant's pleadings. I don't know if a jury has been paid, a jury fee's been paid. But again, Your Honor, we think there's a major issue of standing here. They have not presented any evidence that she's an owner or member. And I think if you decide that first, if you find there's no standing, then we won't have to go forward with a receiver or the kind of merits of whether a receiver is appropriate.
That's simply not true regarding no evidence. We've filed repeatedly her 50% interest that Daniel Watson memorialized in 2013 and 2014 tax returns. We filed his blood oath conveyance of 100% interest in the Angel Sword entities, which he signed and sealed with his own blood, drawn from, I guess, his hand with a knife. So, no, I think, those, yes, as bizarre and as unique as that is, Judge, we take Mr. Watson at his word that he was conveying these assets to his beloved wife, or his dear wife, as he called her in the missive.
And Your Honor, we've given you a half dozen reasons why there was no conveyance in our response. We're the only ones that have submitted evidence. And so we do think that standing issue is the first thing the court needs to decide. She's got to be an owner or member. That's the black letter law of the statute.
I don't think I disagree or agree with either of you on the merits of this. I think I'm trying to deal with the procedural issues, which are, you know, I think in order to make a determination on this, and that would include your right standing as well as, let me just, sorry, I'm having some issues here. All right, there we go. That would include standing. That would include, are they an owner? I don't see that a jury fee was paid on this. Rhonda, can you check to see if a jury fee was paid? I think the most expeditious way to handle all of this would be just to try it on April 20th, unless you paid a jury fee. Just try the whole thing. Let's figure out if you have ownership interest, figure out everything, and we can get it resolved that way. I don't know if the blood cutting your hand thing is proper conveyance or not, but I do think that in order to make a determination, let's say that even if they are a member, if it's appropriate to wind it up, I agree. The first issue is, do they have an ownership issue? Then the second issue is, if they do have an ownership issue, should it be wound up? Is this something that's appropriate for wind up? I think you need a trial on that. I think that we just hear it all on April 20th, unless you paid a jury fee, and I don't know that you have. I don't see one.
And Judge, what would you, if we did it that way, which I certainly am fine, what would you want to do with respect to all of our tort claims? Sever those for?
Nope, try it all.
Okay.
Try the whole thing. And part of it would be, I mean, what we did in the TGI Friday case is there was, I don't remember, numerous claims made by one side, the plaintiffs in the case, and according to this, it wasn't. It was not paid, according to my court coordinator. You can verify that. Just try the entire case. You know, submit findings, proposed findings of fact, conclusion of law. We'll try the issue of standing. Try the issue of whether or not there's a partnership interest, or try everything, and just do it all at once. That seems to be the most efficient way to do it, and I'll have plenty of time to do it because it's a trial.
Fair enough, Judge.
Your Honor, if I may.
Mr. Hill?
Yes, Your Honor. Really kind of two things. The court's already heard a motion to transfer this case to Hayes County, Texas, and that's been denied. Ms. Watson initially tried to bring this suit into the divorce proceeding down there, and this court denied that. There's an ongoing divorce between Daniel Watson, my client, and Mr. Henley's client. And citing the cases that Mr. Henley filed in his motion to transfer, my client being brought into this suit is believed inappropriate, which is basically spelled out in the pleading jurisdiction. There's a separate divorce proceeding pending between those two parties. I asked the court review my filing and the court's file and dismiss my client out of the case.
So what may make sense on that issue, and I think that's a good point, Mr. Hill, is maybe we hear the plea to the jurisdiction. I don't want you to have to spend all weekend getting ready for trial. Maybe hear the plea to the jurisdiction the Friday before trial so that we can make that determination.
A secondary part of that, Your Honor, is my client, since he was just brought in.
I'm sorry, say it again.
Since my client was only just now brought into the suit, doesn't have 45 days notice and has not been able to participate in any discovery whatsoever.
Mr. Henley, why is he even in the suit? Why is he even necessary?
He's the real party in interest, Judge. I mean, he's the actor pulling all the strings. This is a complete fiction that this does not involve the husband. I mean, he's the one who's conveyed these things. He's also the one who committed a lot of these personal torts, including the malicious prosecution of Oksana Watson. I mean, the idea that
all of that should be in the family court proceeding. I don't know why that would be
Your Honor,
here.
it's been raised in the family court proceeding, so it's already live in Hayes County, Texas. And on.
I'm just saying, Mr. Henley, you're risking everything here by including him in here. I'm just saying. I mean, this that makes me think if he's in this, then I may reconsider my decision and transfer it to Hayes County, because before you know, you can't have your cake and eat it too. You said, hey, look, this isn't a case against Mr. Watson, I think his name is, and it's only against the company, blah, blah, blah. And then you add him in after I make that determination. I think maybe.
Judge, we were the defendant. We have been saying all along that Daniel Watson is in essence operating behind an alter ego. That it's not. We've absolutely maintained that.
The judge, last fall, their position was, hey, transfer this into a divorce case in Hayes County. And you had 2 hearings on that. We told you what this was. This was plaintiff corporate entities attempting to recover embezzled money, and you denied that. So months go by, and all of a sudden the tact in February is, oh, let's name Daniel Watson as a third-party defendant. Let's urge completely new claims against him. And then apparently now they want to take them to trial within weeks. We didn't hear a peep out of them. And then they moved for, extremely extraordinary relief in February on this application. I think there is a bridge of, yes, all the corporate issues, including the application, can be heard by you, but these tort claims against Mr. Watson need to be taken out of this case.
Yeah, I'm inclined to think that the tort claims against Mr. Watson. So I'm sorry, I misremembered. You're right, Mr. Henley. So the tort claims are between Miss Watson and Mr. Watson, correct?
Yes.
And had you moved this to Hayes County?
I did, because the gist of why they dragged this woman into Dallas in the first place is they've asserted that she stole from the company, which was a company that Daniel Watson supposedly owned and operated by himself, despite the fact of having formed it after they married, and despite having conveyed his interest to Ms. Watson expressly in tax returns.
Okay, so what my thoughts are is that the tort claims probably should be transferred to Hayes County between Ms. Watson and Mr. Watson. If you're going to keep those, those should probably be transferred. And then the claims between Angel Sword and Ms. Watson would be heard on April 20th. And that would deal with Mr. Hill's issue. That would deal with really all of the plea to the jurisdiction. I think that's what makes the most sense, because that should be covered in the divorce. But what do you think, Mr. Hill?
Your Honor, I actually think that the transfer would be inappropriate. I just think they should be excluded here, and Ms. Watson should properly file them in the Hayes County case. It's not prejudicial to her at all. I think transferring those out is kind of confusing, since the suit was initiated by the entity against a former employee and isn't part of the divorce case. I don't think those claims are appropriate in this court. I think they are most appropriate in the divorce case. I think tort claims are appropriate to be brought.
What if we did this? What if we severed those claims out and then transferred the severed case?
I think that would
I agree with you. If I don't do it without a severance, it would be very confusing.
Yes, Your Honor. Yeah, if they were severed and transferred after severance, then I think it would be perfectly fine. And it would be appropriate under the family code to have those personal torts between spouses within a divorce.
Mr. Henley.
Judge, they've been dragging their feet for like 4 years. I just got involved in this. Sir, you do not cut me off.
Mr. Hill, let him finish.
And the idea that they would, for this action, again, they had this woman jailed in Hayes County by the basis of alleging that she had embezzled these funds. This is all related to the same course of action associated with the ownership of this company. Daniel Watson was running this business out, was running his personal finances out of this own business. And when his wife had offended him subsequent to that, he decided to have her indicted. All of these things are inextricably linked. And as a result, Daniel Watson is a necessary and proper party to the ultimate disposition of this case. What Mr. Hill is hoping is that we're going to have inconsistent outcomes in Hayes and in Dallas, all their own doing. If this all had stayed in Hayes County, where virtually everything took place, I mean, you evaluate Mr. Vassar's proof and they go and get a CPA down in Austin. All of this could have stayed in Hayes County, but because they wanted to bring it up here and because Your Honor determined that there was, some basis to keep it here, then they need to have everything heard, including how this woman has been dispossessed and certainly abused.
All right, so what I would suggest at this point, since there's not an agreement on this, is if Mr. Hill, if you want to follow a motion, so I'll hear the plea of the jurisdiction the Friday before trial. If you want to follow a motion to sever and transfer those claims, I'll hear it then. I'm just trying to figure out a logical way to do this that kind of accommodates everything. If Mr. Henley doesn't want to agree to that, that's okay. He knows more about the case than I do. I'm not trying to, trying to give everyone a fair shot here.
Just to briefly respond, this case, on lead counsel in the divorce case for Mr. Watson, we've been set for final trial 4 times. The first time was in December of 2019, and the delay was Ms. Watson seeking the delay. It's been delayed for over 14 months. Well, I guess 16 months now by Ms. Watson's requests. I would be more than happy to try this divorce and get it over with in Hayes County, Texas. But because of Ms. Watson's continued requests and going through 2 different lawyers in the last 14 months, we haven't been able to try that case.
It may also be COVID as well, but I don't know. But anyway, so I've given you guys marching orders. The plea to the jurisdiction will be heard on the Friday before trial. Let me just kind of look at the dates here.
Could that possibly be the Thursday before trial?
Thursday the 15th?
Yes.
You're just not having a lot of time here. What's your issue with the?
I'm scheduled to be out of town on the 16th.
Oh, the trial. What is the trial set again? Is it the 20th?
20th.
Okay.
Oh, which is a Tuesday.
Yes.
What's your issue with the 16th?
I've scheduled to be out of town, Your Honor. I don't have a vacation letter, but I've scheduled to be out of town. I was just seeing if you had another date for it.
I could hear it on the 12th, or I could hear it on the 19th.
We would prefer the 19th, especially since it's the day before. I mean, getting all the.
It's kind of a little unfair to Mr. Hill.
I'm on schedule for an in-person contempt hearing in Hayes County on the 19th.
We're fine. I'm fine with the 15th or the 16th.
With respect, trying to accommodate Mr. Vassar.
Mr. Vassar, you're not really you don't really have a dog in this fight, do you?
I guess not on the, not if you're going to sever out Mr. Watson, that he's represented by Mr. Hill. So.
And you can always zoom in if you need to, but we'll set it on the 16th. Let's set it at 10 o'clock, and we'll set the plea to the jurisdiction as well as the a motion to sever if you end up deciding you want a motion to sever and transfer, or at least the motion to sever, and then we can make a determination if it should be transferred. I don't think there's enough time to do a transfer motion, but with the severance we could, I think. but you can trial both, and then we can figure out if you have proper notice on the transfer. So anyway, anything else, guys?
Judge, on the trial, are we going to appear in your
No, Zoom. It'll all be
purely Zoom? Okay.
Purely Zoom.
And so we need to get acquainted with the submission of exhibits and presumably exchange exhibits and do all of that via Zoom or other means.
So one thing I'd highly recommend, I've done quite a few Zoom trials, is that you guys try to pre-admit as much as you can. So make sure you confer on the exhibits, makes it a lot easier. The one issue that sometimes comes up is if there's a situation where you have a party that is going to, you don't want the witness to see it, but you want me to see it. So you may have to do a hyperlink so I can see it. But you know, this is why you hire young lawyers or law firms.
I was, you were reading my face, Judge.
But it really has gone, Ms. Pettit just tried a 3-day trial over Zoom and a bench trial. We don't have a jury. So, you know, I think it'll be a lot easier than you expect.
I kind of like those Elmos and the easels, Judge, and even the chalkboard from time to time. But no, we'll do what we need to, Judge.
Anything else, guys?
No, thank you.
Oh, and we didn't set the time. Does
Oh.
10 o'clock on the 16th work?
Yes, Judge.
Yes.
It does for me as well.
Can you grab, let Reagan let you go this time. I don't know if you've been listening in, but we're going to set the plea to the jurisdiction on this case here. And if they file a motion to sever, they can hear at the same time on December 20th. Sorry, the hearing is going to be on April 16th at 10 o'clock. And it's on cause number DC 207334. So plea to the jurisdiction will be set at that time. And if the motion for severance is filed, it can be heard at that time. That all makes sense? If filed. So just put that in the notes when you set the hearing. Thank you. Anything else, guys?
No, Your Honor. May we be excused?
You may. You guys have a good day.
You do the same, Judge.
This has been a busy, busy morning. Bonnie Aldridge versus Alrea Johnson.
Yes, Harvey Joseph here for the movement, Alea Johnson.
Okay. Anyone here for the non-movement?
Yes, Your Honor. Benjamin Pelletier here for Bonnie Aldridge.
Okay, great. All right, Rhonda, let's go on the record on cause number DC 1917233, Aldridge versus Johnson. Counsel, make your appearances.
Harvey Joseph on behalf of defendant Johnson, Your Honor.
Benjamin Pelletier on behalf of the non-movement and plaintiff, Bonnie Aldridge.
All right, let's proceed.
Yes, Your Honor. This is defendant Johnson's third motion to compel in this case. I believe the first two motions were granted. And this motion, Mr. Pelletier had promised to supplement answers to certain interrogatory questions, and they've yet to be supplemented. And this is going on, I think, over 18 months now. They're interrogatory questions 3, 4, and 5. They're attached to the motion. It's really a small motion. We'd simply like those interrogatory answers supplemented as promised. And that's all I have, Your Honor.
Okay, response?
Your Honor, I do not deny or oppose the relief sought. I would just offer a brief explanation, which is that my client is an elderly woman, and it's just been extremely difficult to get the information that's requested. Although I don't deny that the defendants are entitled to it, and I will, pursuant to the rules, obviously, and to the court's, court's orders, I will do my best to make a fulsome response.
Okay. Let me just look real quick. So the proposed, wait a minute, am I looking at the right case? And you said you submitted an order on this already?
I believe so, Your Honor.
Let me share a screen. You can tell me which one it is. Because there's been a lot of motions to compel in this, so I want to make sure I get the right order that you're requesting. Oh, and you guys are set for trial next week too. We can reset you if you want, because we're not going to have any jury trials next week. I don't see an order in here. Do you see one?
I see the notice and the motion. If there's not an order on the third motion, I think that your court coordinator had recently requested resubmission of the order on the second motion. But on the third motion, I can certainly submit an order today, but it's simply for them to fully respond to the interrogatories. They didn't object.
Is this the second order here? Have I not signed this one?
You must not have signed.
Oh, no, I did. I did sign the second one.
Yeah, that's the second order. That is the second order.
Yeah, I did sign it. So sometimes in COVID things get lost, but I did sign the second one. So if you could go ahead. I'm sorry, I don't mean to interrupt you. What were you going to say?
I said we would submit a third order today.
Are you seeking sanctions on this or no?
We are not. And the second order suggested that they would be on the table if we had to keep moving for these. We did move for yet another motion, but I understand Mr. Politari's problem with the client. I would just say if the client is unable to proceed with this lawsuit, then the lawsuit should be dismissed if they're unable to participate and proceed. Because my client is here involuntarily. We're not seeking court relief. We're a defendant. So
that's. I'm sorry. I'm sorry. I didn't mean to interrupt. That to that point, that is certainly being looked at very carefully.
So, to the extent on the third order, the short answer, Your Honor, no. We would just simply like the order that the interrogatories be answered. That's all we're seeking.
So go ahead and get me an order. Make sure on the order it says on April 2nd that I heard this, that you're not seeking sanctions at this point, and then detail what I've decided here. You have a trial setting next Tuesday. I can reset. We're not going to have jury trials next week, although we do have now a schedule for jury trials for the summer. They're very limited, but we do have some trials. It looks like the 68th. I don't know if you've heard how this is going to work. Did you hear what I told the previous attorneys about how jury trials are going to work this summer?
I heard only that it was extremely limited.
That's what I heard.
So the way it's going to work, I think, if everything, at least what we've been told at this point, is essentially we're going to have one jury setting in June for the 68th and for each other court in the George Allen, and one jury setting in July. My jury setting in June is during the week of June 22nd. My one in July is during the week of July 19th. So if you want to go to trial on this, you know, I could set you either of those weeks or at some point after August. Or if you guys just want to talk about it and come back on Tuesday, we can decide it then. It's up to y'all.
If we're able to come to an agreement on a proposed trial date, do you still want us to appear on Tuesday, or can we do that by submission? Or
it depends if it's on a date if it's on one of those two dates, I'll do it by, you know, agreement. But if it's on a date that I'm not available, then you still have to show up. So if it's either the first date, the second date, or after, or August or later, you don't have to show up.
I think we could say now, I know Mr. De Diego's schedule is very busy this summer. So I would say for the defense, August or later.
I'm with that.
If you guys can come up with an agreed date, get that to me as quickly as you can. If you can't, or do you want to do an agreed date right now, or do you want to chat, or I could put you into a breakout room if you want to do that, whatever works, or you can come back, or you can submit something.
Ben, what would your preference be?
I'm happy to select you know, a date in September.
Okay.
And what is the court's, as of right now, is the court's docket essentially open for September?
The 7th, the 14th, or the 28th are dates, as far as I know. Again, this is a constantly moving situation. Things keep getting moved without any consultation with the judges. So as of what I know at this particular moment, that is true.
Okay. Well, I would propose the 14th.
Does that work?
I'm going to be speaking for Mr. De Diego. So I'm not sure. If you gave me a minute to step away and look at the calendar, I could tell you in about 30 seconds, but I'll need to get to another computer.
Go ahead.
Thank you. You know.
While he's doing that, is on the folks on the Encore Electric case, are you guys still going forward with this hearing?
Yes, Your Honor.
Okay.
I'm back, Your Honor.
All right. What'd you find out?
Mr. De Diego has 2 trials set on September 14th. 1 trial already set on September 28th. Unfortunately, due to COVID, he's got trial settings from the summer on almost every week. You know, as an insurance defense lawyer, you get a lot of trial settings.
Yeah.
So, well, obviously they're not all going to go. They are already on the docket all the way through November, Your Honor.
Okay. Well, just come back on Tuesday and we'll chat about when we can move it. Just make sure you have your calendar available. Okay.
Yes.
Very well, Judge. Thank you.
See you guys on Tuesday.
Thank you. Your Honor.
All right. Bye-bye. Encore Electric versus Central Transportation International. both sides here.
Bryce Anderson for Central Transport, Your Honor.
Eric Walker here for Encore Electric Delivery Company.
Okay, let's go on the record on cause, or do you guys need a record for this? It's a summary judgment. We usually don't, but it's up to y'all.
Not for me, Your Honor.
I don't think so, Your Honor.
Let's proceed.
Good morning, Your Honor. This case arises out of a alleged incident involving low-hanging wires. Encore alleges that Mr. Carlos Pozo was driving and struck the wires and damaged Encore's utility poles. They allege roughly $7,000 in damages. Encore filed suit against Mr. Pozo, as well as his alleged employer, my client, Central Transport. The claims against Mr. Pozo are negligence and trespass to property, and for Central Transport, vicarious liability for those claims. As of today, Mr. Pozo has not been served. He has not appeared in this action. There's been no discovery served by plaintiff on Central Transport. And despite written discovery to plaintiff from Central Transport on September 8th of last year, there's been really no response at all to that discovery. No documents produced by the plaintiff in this whole meantime. And last month, Central Transport filed its no evidence motion for summary judgment. Despite the response from plaintiff Encore, there's no competent evidence to oppose the no evidence motion because none of the documents were presented during discovery. Under Texas Rule 193.6, evidence that's not timely produced during discovery that is responsive to discovery requests can't be used to oppose a no evidence motion. The Texas Supreme Court clarified that the rule applies to no evidence motions for summary judgment. And even presuming that these documents are competent, there's no real fact issue here at all. Of course, plaintiff has to prove that Mr. Pozo was acting in the course and scope of his employment for Central Transport at the time of the incident. In its response, plaintiff identified exhibits A1 and A4 as supposedly providing evidence of course and scope. However, exhibit A1 is just the police report that identifies Central Transport as the owner of the vehicle. There's no indication that Central Transport was negligent or was the employer of Mr. Pozo at the time of the incident. Also, this exhibit A4, which is a communication from plaintiff with Cherokee Insurance Company. This is simply an insurance communication. In fact, it identifies Central Transport LLC, not my client, Central Transport International. There's no mention of Mr. Pozo, the driver, and there's simply no indication here that at the time of the incident, Mr. Pozo was in employment of Central Transport International. And on that basis, Your Honor, these documents produced, they weren't timely. There's no evidence here of respondeat superior against Central Transport. And for that reason, the motion, the no evidence motion should be granted.
Response?
Your Honor, I would like for Mr. Anderson to check his email and confirm to the court whether he does have an email from me that has document production, including these documents. Granted, it was sent this morning, but it has been produced in advance of this hearing. It includes the exact same documents that were attached to the response. Mr. Anderson, do you have that email?
I see an email at 10:20 this morning. Yes, sir.
And that is before the time of this hearing. So from our perspective, those documents were produced in response to discovery, albeit not as soon as I would have liked initially. These documents are no surprise. They cannot be a surprise. And Mr. Anderson does not deny that Cherokee Insurance represents his company as the insured. And if you're taking a look at the documents themselves, I think that it's pretty clear. You have Mr. Pozo, who is the driver. It identifies Central Transport as the owner of the vehicle. The way these claims are usually worked up is the police report is brought in. You identify whoever it is who's in there, whether it's Mr. Pozo, Central Transport, then you send out communications. One such communication was sent, and that's Exhibit A2 to Central Transport back on February 1st of 2019. Then you take a look, and it's just 4 days later, you get the response, and that's Exhibit A4 from Cherokee Insurance. So what you have is a situation where on Exhibit A1, you have the Stevens Road in Warren, Michigan address. That's for Central Transport, the entity. Yeah, Central Transport coming back in Exhibit A2, same entity that was responded back for Cherokee Insurance Company. Now, in that document itself, the insurance company says the line struck by our insured and identifies Central Transport. Also talks about how the top right corner of Unit 2, which was Central Transport's vehicle in the police report, struck the wire and pulled it down. Getting to what we have in terms of the actual claims here, we attached, or not attached, but we cited with a link, if the court wants to take a look at it, a case from the Dallas Court of Appeals from March of 2019, Babier versus Kelly. And it explains very recently what the duty to keep a proper lookout encompasses. And it's not, I just measure my truck, I get to drive around and do whatever I want with my vehicle as long as it's the 12'6" typical measurement. You still have to be aware of what's around you. You can't just plow through other cars. You can't just drive over other people's property. And even if there is a wire that is low hanging, the driver still has to have a proper lookout to be able to, in the words of the court, observe in a careful and intelligent manner traffic and the general situation in the vicinity, including speed and proximity of other vehicles, as well as rules of the road and common experience. And then it goes on to talk about anything else that could be avoided as part of it. So we believe that.
Okay. I apologize. I'm just kind of running out of time. Any response to that?
Yes, very quickly, Your Honor. This was an expedited level 1 case filed by Plaintiff Encore as a level 1 case back in June. Discovery ended in this matter 3 months ago, Your Honor. To say that, we produced this evidence 10 minutes before the hearing date on a no evidence motion is absolutely not timely. I'll just very quickly read the language of Rule 193.6, Your Honor. A party who fails to make, amend, or supplement a discovery response in a timely manner may not include in evidence the material or information that was not timely disclosed. This is not timely, Your Honor. 10 minutes before the no evidence hearing is not timely. Even last week, almost 3 months after the end of the discovery period, is not timely. I don't know why this evidence wasn't produced to Central Transport back in September or October, but it simply wasn't, Your Honor. And the Texas Supreme Court has clarified that this Rule 193.6 applies to no evidence motion for summary judgment. If it's not timely disclosed, it can't be used to oppose the no evidence motion, Your Honor. And very quickly, just to approach the fact evidence, there's still no fact issue of employment here of Mr. Pozo, Your Honor. Exhibit 1A simply identifies Central Transport as the owner of the vehicle. This isn't an employment record where we can glean some sort of scope, course and scope. This simply implies that the owner of the vehicle was Central Transport. Second, Your Honor, this correspondence with the insurance company, there's no mention of Mr. Pozo at all. I don't know how you could possibly draw a fact issue on course and scope where the employee is not even mentioned. And for either of these reasons, Your Honor, either the evidentiary reasons or the fact issue reasons, Your Honor, the no evidence motion should be granted.
Your Honor, if I may just have a 1-minute response. Essentially, what we have here is, as everybody's aware, is everything has been strained under the COVID pandemic, and including our ability to respond in the way that we would like to. And to the extent that any discovery deadlines are expired in this case, we would ask for the court to extend them for a very brief period of time to allow for this evidence to be able to be considered, since it's not voluminous. There's no undue prejudice. There's nothing really here that shouldn't be considered by the court. And taking a look, it says very clearly the lines struck by our insured. That should be viewed as an admission, and we ask the court to do so.
Okay, summary judgment is denied. Let's look at the trial setting on this case. Is this going to continue to be a non-jury case, or have you guys talked about that? It's currently set for July 27th. That might be a jury week. It's kind of up in the air. Is there any way we could move this case up at all? And what I was thinking of is maybe to July. It would be helpful if we could do it at least to the court, just based on if we can maybe try it either in June or on July 13th. If not, we can, and the issue is we're going to be having jury trials. They've set a new jury trial schedule where each judge is allowed to try one case essentially a month on a specified day. That could change. It keeps changing, but we're looking at the 68th is going to be having a trial during the week of, and this schedule we have goes up through the July 23rd. We would be having a trial during the week of July 20th. So, and then after that, I'm not sure what the plan is, but it's possible we may start regular jury trials. And if this is going to continue to be a non-jury, it might be better to move it up a couple of weeks. But if that's a big problem, we'll just leave it where it is.
And the July 19th, I already have a trial setting, Your Honor.
I was talking about the week before that, because I have a trial. That's my jury trial week. So I'm talking
July
about
12th?
Yeah, if you can. If you guys can't, we'll just leave it where it is.
Central Transport is fine to leave where it is, Your Honor.
Leave it where it is or move it up?
To leave it where it is currently on the 27th.
You don't want to move it up?
Correct, Your Honor.
Okay, then we'll just leave it where it is.
Okay.
All right, guys. Did you submit an order, Mr. Walker?
I don't believe I did, but I can submit one very shortly.
Make sure on the order that you include that it is that I heard this on April 2nd, 2021, and it's just a simple denial of summary judgment.
Will do.
And e-file that, as well as email my court coordinator as soon as you can.
All right, I will do that as soon as we're done.
All right, thank you so much.
Thank you, Your Honor. May we
You guys have a good day.
Go
The next case I think we have is in re matter of annuitant, cause number DC 212506. Anyone here? Kent Hansen? Anyone here in that case?
All right. Good morning, Your Honor. Andrew G., local counsel for StratCap Investments, Inc. I'm here at my office with Mr. Vasquez Garcia.
Okay. I think you guys submitted something last week on this case. Is that right?
We did, Your Honor. We have a summary of Mr. Vasquez's testimony, a business plan or / financial sheet. He's here sitting next to me. He can scoot over and he can, we can call him as a witness and prove up the case if that's convenient for the court.
Yeah, we're not going to have any testimony. So let me see. So
the reason I ask, Your Honor, is his English is he understands quite well, but he's got a mask on, speaking over Zoom. We do
Okay.
have a lady from office who's a Spanish speaker who's available, Ms. Rojas, and she's available to translate if you like.
Okay.
I can give the court maybe the most efficient thing for the court would be for us just to call Mr. Garcia, ask him, if what's in his statement as a summary of his testimony is true and correct. We can talk about the details of the transaction.
What I want to find out first is kind of what exactly is the transaction?
So what it is a sale of he receives a payment each month of $1,302, and he's breaking off a pay of 390 of that, so about 30% of his monthly payment.
Okay.
He's selling that portion, and their payments between
how many payments?
490, and it's between June 2021 and July 2057. So 443 payments.
Oh my God! And how much is the total? Not discounted. What's the total?
So the aggregate is $169,000.
Wow. Okay. And what is he getting in return?
So the purchase price is $50,000, which equates to an interest rate of 8.8%.
Okay. And then are these guaranteed payments or are they life payments?
They're guaranteed payments, Your Honor.
Wow. Okay. And then I saw the plan. It looked like the plan was only for $10,000 or $11,000. I'm not sure why he's selling $50,000 worth then.
So the plan, I don't believe the plan included the vehicle that he needs for the business, which is, and he's here to talk about that, but it would be an F-250 pickup truck used. Those are about $25,000.
Okay.
So the equipment is about $35,000. And then he has about 15 set aside for gas, salaries, things of that nature.
Okay, you're selling $169,000 of guaranteed payment for just $50,000. Okay. And so what does he do right now for a living?
So he works at a steel factory, and he takes home $3,600 per month on that.
$3,600.
Yeah, he's got 3 kids, and he wants to start this side business because those children will, at some point, hopefully go to college, get married. He tells me his children are expensive, and he wants to have something put aside for their futures.
So he currently makes $3,600 a month, and then he also does. He also gets this annuity of $1,300 a month, right?
Correct.
Okay. And so this is business. How would he do this if he's already working?
So he has a Monday through Friday job. So he'd do the handyman and lawn service on the weekends, and he's researched the market and determined that he can get at least minimum, he thinks, to start off with 4 customers a month at $50. And then he thinks ultimately he can grow that business. He thinks there's quite a bit of demand for that over the weekends when people are home. He also has a large extended family, and folks in that family are willing to work with him on that business as well.
Okay.
And he believes he can make about $3,600 a month net profit when the business is mature.
Just working weekends, he can make $3,600 a month.
Yeah, he believes he can. Yes.
And how? Let's think about this. So let's say he did. How much is he? This is for mowing grass. How much does he get paid per? Or has he ever done this?
He has done it. Yes, and he thinks he can get at least a minimum of $50 per visit.
Okay. That seems really high, but 50 per visit, and then he would have 2 days. I don't know how you would do that. I mean, if you're just working weekends.
You'd have to do, when it's fully extended, you'd have to do 9 visits per per weekend day. And that might be too much for him to do. But again, he's got an extended family and he's got some other people to help him
But
do.
that's grossing. That's not net. That doesn't count what he's paying people. That doesn't count. I mean, he's selling a lot. I mean, he's $169,000 worth of payments. So what was this for? What did he? How old is he?
So he's 29, and this is from the wrongful death of his father, a claim that was settled in 2016. 2016, yes, about 5 years ago.
We set up an annuity on that?
Correct. And he has no prior transfers.
And what? So he agreed. So this wasn't when he was a child. He agreed to this annuity payment as an adult. Is that right?
Yes.
Okay. Well, I guess why? Maybe he need to hear from him. Why did he agree to these annuity payments if he was just going to sell them? Let me hear from him on that.
And we may want to have Rocio just ask that.
Can he answer that, or does he need a translation?
Can you answer that, or is it helpful if you have Rocio? Yeah, he's asking if Rocio could repeat the question.
Okay. May I translate, Judge?
Yeah, go ahead.
Okay. Julio, lo que está preguntando el juez es cuando usted se puso de acuerdo de los pagos, cuando lo que pasó con su papá, el juez quiere saber por qué usted decidió hacer esos pagos. Bueno, al acuerdo que tiene ahorita, ¿por qué usted a ese momento decidió hacer esos pagos?
Para poder emprender a hacer un negocio y, y poder pues proveerle pues algo mejor a mis hijos, a mi esposa, generar un poco más de dinero.
Lo que está preguntando es al principio de
Just translate what he said.
Okay, he's confused. He's thinking you're asking why
just tell me what he said. Just tell me what he said.
He says he is wanting to do it for his family. He wants a future for his kids. His kids are going to grow up, and he wants to make sure that he will be able to help his kids if they go to college or etc.
So, but why did he agree to do the annuity to begin with if he was just going to sell it? I think you're right, he is confused, but why did he agree?
Right.
He agreed to do this annuity 4 years ago to pay it out over this whole life. Why is there a change in circumstance that he's wanting to do this now when just 4 years ago he wanted to do an annuity?
Yes, Judge, that's what I was about to explain to him.
Okay.
Julio? Sí.
El juez, creo que se confundió. Lo que está preguntando el juez es al principio cuando todo pasó con su papá y hicieron lo de acuerdo con los pagos de su papá, ¿por qué usted decidió esos pagos a ese momento? Cuando pasó esto, cuando su papá pasó.
Sí, pues en ese momento pues no pensaba lo que a un futuro iba a venir. No pensaba que pues un día iba a ocupar ese dinero. Y por eso fue la razón que yo decidí meter ese dinero allí. Y ahorita como está la necesidad de que ahorita tenemos poco trabajo y mis niños pues están creciendo, y por eso es la razón que ahorita estoy pidiendo eso.
Okay. Judge, his response is at that moment he was not really sure what to do. Everything was happening so fast, and he didn't really have as much responsibilities as he does now.
Did he have kids at that point?
Julio, ¿usted tenía niños en ese tiempo? No me acuerdo.
Sí, estaban chiquitos.
¿Cuántos tenía?
2.
¿Y ahorita tiene 3?
Sí.
Okay. Judge, his response is yes, he had 2 kids at the time. They were babies. And now he has 3 children.
Because if we had not done the annuity, he would have had a lot more money than if we do this. That's my concern is that we just 4 years ago set this. He's giving up a lot of money in terms of that what could have just been straight cash to him. And so I'm just trying to figure this out. Has he talked to the bank about getting a loan?
Yes, Judge, he has. He has actually, I can ask him if you want, but
Yeah, go ahead and ask him.
Okay. Julio.
Sí.
El juez está preguntando si usted ha tratado de agarrar un préstamo con el banco.
Sí, sí, intenté, pero el crédito que tengo no tengo un buen historial de crédito, no me aceptaron.
Y, ok, so cuando usted dice que no tiene crédito para nada o tiene crédito malo.
Un poco crédito, no me pudieron aceptar, no calificaba para lo que yo quería.
Okay, Judge, his response is yes, he did attempt to get a loan with the bank, but he was denied due to not so great credit.
Okay. Give me 1 second.
Yes, sir.
Okay. What levels of transaction has he looked at besides this one? Because this is such a huge transaction.
You're asking if he's had any other transactions, or I'm
No,
sorry,
like when he was talking about selling all these payments, it's 490 payments that he's selling. Did he discuss with them doing a smaller transaction?
Julio.
Sí.
El juez está preguntando porque él está un poco preocupado de la cantidad del préstamo la cantidad de el dinero que usted está tratando de vender, y está preguntando si usted ha pensado de no hacer tan grande del dinero de que quiere vender. O sea, si no pensó de hacer menos dinero, de vender menos dinero.
No había pensado en eso. No he pensado en eso.
Judge, his response is no, he hasn't really gave it a thought as far as doing a lower transaction. He's pretty set on what he is wanting to do, on wanting to sell.
I mean, you're giving up $169,000 for $50,000. Have you thought at all about, so you get these payments of 490, is that 40 years worth of payments about? Is that right, Mr. G? Am I getting the math right? 40 times 12. Yeah, it's about 40 years worth of payments. Mr. G, is that correct?
Judge, it's about 36 years of payments. And I will just kind of observe as someone that's bought a lot of used cars over the years that has at least okay credit, getting a loan at 8.8% on a used vehicle. If he were able to finance something through a dealer, he'd probably end up getting a much higher rate, especially if he's got poor credit. I mean, I see clients all the time come in on other cases, and it's not unusual with someone with bad credit to pay 15% on a used vehicle loan. And most of the money is either going to equipment or to the vehicle. If you were to put it on a credit card, it would be much higher than 8.8%.
I just don't see that this is, I'm not opposed to doing a sale. I just don't think this sale is fair to him. I understand why he's trying to do it. I think he would have been much better off not putting this money into an annuity if he was going to do this. I mean, he's losing a ton of money. Mr. G, if you can come up with a better deal for him, whether it means selling less payments, maybe at the back end, or doing something different, I'll reconsider. But I just don't think this particular deal is a good deal. And so if you want to reset this, or what do you want to do, Mr. G?
Yes, Judge, we'd like to reset it. I'll go back to StratCap and we'll come up with some other options for Mr. Vasquez.
And one option I think might make sense is that as he gets older, I think he's going to need these payments more, because does he have retirement at the steel company?
Do you have a retirement program? You're muted, Rosie.
Oh, sorry about that. Si entiende, Julio, está preguntando si usted tiene un programa de retirarse con su trabajo que tiene ahorita. O sea, no está en una programa con su trabajo de cuando usted decide de retirarse. No. His answer is no.
Yeah, I mean, he's going to need these. This is great for his retirement as he gets older, especially if he's going to rely just on Social Security or however he's going to do this. And so maybe not sell the last 10 years worth of payments or something like that, where you can front load it, less money front loaded. But this particular deal just, I don't think is fair to him. I understand why he's doing it, but just see if you can get him a better deal, maybe cutting out some of the later payments so that he can keep those for his retirement, but keeping the same 50,000. That would be my suggestion. But just see what you can do, and then we can reset this. We'll put this on a 30-day. How long will it take you to talk to them, Mr. G?
We could have something a week from today.
Do you want to just reset this in a week or 2 weeks, or what do you think?
Why don't we do 2 weeks? I think my client's offices are closed today for holiday.
Okay.
But we can do it in 2 weeks.
Does that work for him?
Can you do it 2 weeks from today? And I'll just check my calendar real quick.
Julio, ¿usted tiene tiempo para regresar a hablar con el juez en 2 semanas?
Yeah, we can do the 16th.
He says yes.
I will note, Judge, that on the payments terminate, he's at age 65. So I think it's not unusual for people to work up until that time. But if you like, we could look at front loading some of the payments, and then there's more money on the back end.
I want him to sell less and then front load. So, or what my thought would be, he's selling essentially 36 years, instead sell, maybe 28 years, and then, but for the same 50,000, the same amount. So I'm not trying to restructure. I'm trying to get him a better deal.
Okay. All right. We'll see what we can do.
Okay. Thank you guys. Good luck.
All right. Bye-bye.
Hey, I'm sorry. We're going to do it at 11 o'clock again, or 11 o'clock in 2 weeks.
Thank you, Judge.
Thank you, guys.
All right. Bye.
Bye-bye. All right. Both sides here in Sorrells versus Allen.
Yes, sir.
Good morning, Your Honor.
Okay, and we're here on, I've read this motion for attorney's fees and sanctions. This is involving the TCPA and the where I dismiss some but not all of the causes of action. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay, so something I need briefed on this, and because I know there's been some different case law on this. In a situation where I dismiss some but not all of the claims, are attorney's fees still appropriate? I recall that there's cases that say that it's not appropriate, but I don't know that for sure. So have y'all briefed that issue?
Your Honor, I can brief it for you now. There's a case cited within our motion. Specifically, it is Schilling Law, and this is a 2020 case, Your Honor. Schilling Law versus Baylor University. Oh, excuse me. And there's also a case that I think more specifically will help, Your Honor, which is SSCP Management versus Sutherland, and that is 2020 out of Fort Worth. And the Second Court of Appeals found that because the trial court had dismissed some of the causes of action, they therefore remanded for the trial court in order to assess the amount of attorney's fees. Additionally, Your Honor, I was reviewing this argument earlier, and if you look at, well, may I share my screen with you? Your Honor?
Go ahead.
So if you look at the beginning of chapter 27 of the applicable statute, and we have here that the legislation has provided definitions in which to interpret this statute, and it actually interprets legal action to mean a lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim. So causes of action is actually included in that definition. And I believe that in conjunction with the SSCP court, which in 2020 expressly held that the dismissal of some causes of actions merited an award of attorney's fees and remanded for the decision on the same.
Can you share screen that case out of Fort Worth?
Yes, Your Honor. I'm not tech savvy enough to do it all at once.
Okay.
Your Honor, here at the top, we have SSCP Management versus Sutherland Palumbo LLC. This is a 2020 decision in the neighborhood of Dallas, just next door. And they go through the merits of the dismissal first as to each cause of action.
I'm only concerned about attorney's fees.
And then at the end, there's this paragraph that addresses, because they've ordered the dismissal of some of the claims, they agree that the TCPA mandates the appellates recover some amount for attorney's fees and sanctions. And I to be honest with Your Honor, I did try to find some case that allowed some sort of further guidance as to how they would apportion the attorney's fees, whether it was all or just a portion. And I haven't been able to find that specifically, but this is a recent case that allowed for that.
Mr. Sorrells, have you briefed this issue?
Yes, sir. It's in my response, paragraphs 2, 3, and 4. That pull up.
And just while Mr. Sorrells is pulling up his response, Your Honor, we did file an objection to the untimeliness of that pursuant to the local rules of the Dallas County Courts, District Courts.
Let me just see real quick. When was the response? I don't even see the response. When was it filed?
It was filed yesterday, Your Honor. And she is quoted 2.211. I have the local rules attached as Exhibit G, and you don't have it. I sent it to Rhonda yesterday just so that she could forward it to you. Since it was.
Let me see if I got it. I don't see it.
It was filed at 6:15 last night, Your Honor, if that is
6:15 last night. Okay. Well, No. Oh, here it is. Okay, yeah. Sorry, I've been in hearings all morning. Let me take a look at it. Okay. Okay, so there isn't anything really directly on point. You haven't researched, Mr. Sorrells, I guess, the issue of under the TCPA, if some causes of action are dismissed and others aren't, whether or not attorney's fees are appropriate. Yours just talks about generally what the definition of a cause of action is. I disagree with you that, you know, they have a number of different causes of action. I dismiss most, but not all of them. Do you know if the Dallas Court of Appeals has ruled on this issue, either side?
I apologize, Your Honor. I did try to look at that this morning after receiving his response, but I did not find one in Dallas County. But that's upon receiving plaintiff's response. That is when I looked within the Chapter 27 for how it was defined within that specific legislative chapter, and it expressly defines it as causes of action and not the suit as a whole.
So what my thought is, this is not a ruling, but my thought is that that I would handle this unless there's obviously case law to the contrary out of the Dallas Court of Appeals, and I wouldn't do this. But my thought is that this should be something like a segregation that you would have, so that you would have to segregate attorney's fees based on which claims were dismissed versus which claims were not dismissed. Kind of, does that make sense if you're familiar with segregation?
Yes, Your Honor. I also considered the fact, Your Honor, that since 4 out of 5 of plaintiff's claims were dismissed and 80% of the requested attorney's fees would also make sense.
Your Honor, I would just have to say that it would be perverse to assess a victim attorney's fees for the things that they've done. My response clearly goes into all the items that they have done to me, and I had no other recourse but to bring suit. I had no idea about the TCPA anyway, but
let me say this to you, Mr. Sorrells. I agree with you that the TCPA at a lot of times is perverse, and the way it has to be interpreted is perverse. I've spoken numerous times at numerous different CLEs and different cases where I think that this was a very, very badly drafted and overly broad statute, and the Court of Appeals has really, and Dallas County has really reined back on this. What my thought is that I want to give both sides an opportunity to research, is there any case out of the Dallas Court of Appeals on this issue? If there's not, then I would, suggest doing a segregation hearing where we would have you would testify, and Mr. Sorrells would have an opportunity to cross-examine you on the issue of what's proper segregation in this case. I'd encourage you to look at the Tony Goyo case on segregation to kind of look at what at least my understanding of the current state of the law is on segregation of attorney's fees.
I believe the court has complete autonomy in awarding attorney's fees.
I don't think, unfortunately, I wish I did. I
mean, as far as the amount goes.
The amount, right, but I think I have to award something. But this is how I want to proceed, is under unless there's something to the contrary, obviously, it would be a segregation analysis. And so, again, if there's something else, any more clear guidance I can get from the Court of Appeals, I'd be glad to look at that. But absent that, I'd do a segregation analysis, and that would require testimony. And I want to have Mr. Sorrells and give him an opportunity. And Ms. Shear, you just got his motion. So when do you want to reset this for hearing?
When is the court available?
Next Friday, the Friday after, the Friday after that? When is it set for trial?
Not until this fall, Your Honor.
When do you want to, Mr. Sorrells, Ms. Shear, when is Mr. Espinosa on this case as well?
Yes, Your Honor, and they have a separate motion that was not set for this morning. We could be available April 16th. We also ask that Your Honor consider our motion for sanctions, just considering some of the allegations that have been asserted against my client in a public domain that are honestly groundless and, do have the potential to injure her reputation as a result.
Does Mr. Espinosa, you said he has another motion, but it's not set for today. When is his motion set?
Your Honor, we have not set that yet. We are trying to get a setting, so I think we can just join in with the.
Is yours on attorney's fees or something else?
Attorney's fees, Your Honor. TCPA attorney's fees.
And I forget how many of the causes of action did I didn't dismiss all of your cause, or what? How many were dismissed on yours?
3 out of 5.
3 out of 5. Okay. All right. So how about 2 weeks from? You said the 16th. Does that work for you, Mr. Espinosa, Mr. Sorrells?
No, Your Honor. I have a job, so I work and I don't do this. The 23rd would be first available for me.
Ms. Shear?
Your Honor, I have a hearing that morning at 9. I could possibly do the 23rd in the late morning or afternoon.
You want to just reset it to 11:15 on the 23rd?
Yes, Your Honor.
Does that work for you, Mr. Espinosa?
Yes, Your Honor.
And Mr. Sorrells, try to get us a briefing quicker than you did. That doing it the night before is puts it, just makes the whole thing a lot more difficult.
I understand, Your Honor. It was in response to Mr. Espinosa's. I thought they were doing it together.
Okay. All right, guys. We will see you on the 15th. I'm sorry, on the 23rd at 11:15.
Thank you.
Thank you, Your
Thank
Honor.
you, guys. And Samantha, you're welcome to come back at 1:30 for the rest of the hearing.
Okay.